Good morning, we're on the record. Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Code Section 2-571 of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting has been conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2-577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson, chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your name. Ms. Terry Janine Quinn.
Ms. Terry Janine Quinn, present.
Mr. David Meadows.
Good morning, Mr. David Meadows, present.
Mr. Ryan Jones.
Mr. Ryan Jones, present.
Excuse me. The board has 4 members for the in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 9 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case this morning is a protest hearing status case number 25PRO00112 Ace Lounge license number 125919. Ms. Doriana, can you please elevate the rights of the parties in this case?
Good morning. Villagat Anbese, access elevated, and Matt Fay, access elevated. That is all, Chairman.
Thank you.
Lago Tambase present.
Do you have a camera you can turn on, sir? Mr. Anbese? All right, good morning.
Good morning.
Good morning. Can you please spell and state your name for the record, sir, and your affiliation with this case?
Lago Tambase, Filagot, last name Anbese, Ace Lounge owner.
Good morning.
Good morning, sir.
Mr. Fay, can you please identify yourself for the record, please?
Good morning, Mr. Chair. Matt Fay, representing ANC 1B.
Spell your name, please, sir.
The first name is M-A-T-T. The last name is Fay, F as in Frank, A-Y.
Good morning, sir. And one of the reasons why I asked everyone to spell their name for the record is that we do have a court reporter just to make sure that your name is spelled correctly in the transcript. Okay, that's why I asked the question. All right, Mr. Ambassador, are there any preliminary matters you need to bring to the attention of the board, sir?
No.
Mr. Fay?
I just want to provide an update to the board. Mr. Mambese Filago was great to meet us in person. We met with him last week. We did a series of sound tests. We met with some of the neighbors who had raised some concerns. We think that we have isolated the issue that led to the protest in the first place. and we are actively working with Mr. Mbese to resolve those issues via a settlement agreement. So although we do not have a settlement agreement at this time, we are working with him and hope to have that settlement agreement resolved in advance of a protest hearing.
This matter is scheduled for protest hearing on February 4th at 1:30. If the parties believe that this matter will be settled without having to go to a hearing, why don't you let the agency know as soon as possible? I mean, we can, because it's the renewal, we can postpone if the parties ask jointly, we can postpone the hearing if the parties truly believe that this matter can be settled through a settlement agreement. Okay.
Very good. Thank you, Mr. Chair. And that is our intention and our hope.
Part of fun. So just want to let the parties know if this matter goes to a protest hearing that our papers due 7 days before the hearing. But as the representation of the parties truly believe this matter can be settled, please advise the agency as soon as possible so we do not have to assign an investigator to this case. Okay.
Very good. We will do that.
All right. Thank you. All right, then you guys have Mr. Mbese, thank you. You have a great day. All right, then. Take care.
All right, thank you, sir. And thank you, Matt.
Are you?
Bye-bye.
Bye-bye.
Thank you.
All right. The next case in our calendar is case number 25 PRO 00109, Amsterdam Cafe and Lounge, license number 115239. This is also ANC 1B. I'm not sure. So, Mr. Orion, can you please elevate the parties in this case?
Sure. I don't see any of the licensees, but I do see call-in users. So I'll elevate just to make sure.
Is there anyone here from Amsterdam Cafe and Lounge?
I'll ask again in the chat.
And Mr. Chair, while he's checking, ANC 1B reached and approved a settlement agreement with Amsterdam at our commission meeting last Thursday. That settlement agreement was submitted, and so the owner may have not thought that they needed to appear today because a settlement agreement had been signed by both the ANC and by the owner in advance of this hearing today.
All right, thank you then for that representation, Mr. Fay. So basically I'm going to postpone this hearing for
I'm
1
here.
week. I'm sorry.
Yeah.
You're here for
Amsterdam Cafe.
but
Mr.
all right,
Bakalu Bible. Yes.
I'm sorry, introduce yourself for the record, sir.
Yes. Bakalu Bible, Amsterdam Cafe Lounge owner.
I'll spell your name for the record, please, sir.
Sure. It's BEKALU. Last name BAYABILE.
And what is your relationship to the establishment, sir?
I'm the owner establishment.
Good morning. Good morning, Mr. Fay.
Good morning.
All right, just introduce yourself again for the record. This is a different, it's a completely different case. So we have to go back through the same process as earlier this morning. Okay, thank you.
I understand and I appreciate that. Matt Fay, representing Commission 1B. First name is Matt, M-A-T-T. Last name is Fay, F as in Frank, A-Y.
Thank you very much. And so this is a different case, a different transcript. So each of the cases, although the parties might be the same, but it's a different case, a different transcript. All right, thank you. And so you made a representation, Mr. Fay. Can you make that a part of the record, please, sir?
I can and would also look for the owner of Amsterdam to confirm his understanding. The ANC at its public January meeting scheduled last Thursday approved by the commission a settlement agreement with Amsterdam Cafe. That settlement agreement was signed by the commission, transmitted to the owner of Amsterdam, and my understanding, although I have not seen a copy of it, is that Amsterdam signed it. So we understand that we have a agreed upon settlement agreement in this case.
Mr.
Bakalu.
Babeka? I'm
Yes.
sorry, Mr.
Yes.
No, I guess your name on the is written. Mr. Babeka, please, what's your understanding of the status of this case, sir?
Yes, correct. Mr. Matt is absolutely correct. So I just signed up with the settlement that we argue with, and that's it.
Have the parties submitted this agreement to the agency?
Say
res-
that again, please.
When
Yeah, sorry. Go ahead.
when will this agreement be provided to the agency?
I'll respond on behalf of the commission. My understanding is that we have received the signed document back from Amsterdam. I believe that it is currently kind of in queue to be transmitted to ABCA. I will reach out to our team today and ensure that that settlement agreement is transmitted to ABCA Legal no later than Friday of this week. And hopefully that transmittal will happen today.
All right, so I'm gonna cancel this hearing pending the submission of the settlement. I'm gonna let me continue this case. Pending is based on the representation of the parties. A settlement agreement will be provided to the agency. So I'm going to continue this case for a date to be determined. Okay.
Very good.
All right. All right. Thank you very much. All right.
Thank you.
Okay. Thank you very much.
I
Thank
have
you,
a good.
everybody.
Thank you. The next case in our calendar is case number 25 PRO 00111 Lost Sock Roasters, license number 132428. Ms. Oriana, can you please elevate the rights of the parties in this case?
Sure thing. Nicholas Cabrera, access elevated, and we have a call-in user that might be part of this hearing.
Okay, who's that person?
I elevated them.
The calling are you the calling user? Are you here for Lost Sock Roasters?
Good morning. Yes.
I know. Hold on a second. I know who you are. I just want to make sure the other party, the calling user, the person. Are you here for Lost Sock Roasters?
To unmute, please press *6.
I'm here for Lostock Roasters.
Sir, I'm aware of that, sir. I'm aware that you're here. So you're the owner. Is that correct?
That's correct.
Right. I'm waiting to see if the protestant is here. So I'm
Yes.
aware that you're here, sir. I'm just there are two parties. I need to make sure before that both sides are represented, so I'll know how to proceed. Okay. So just hold tight, sir. Let me just find out if the protestant's here. Is there anyone is there anyone here for the protest here in Lost Sock Roasters? If please identify yourself in the chat if you are here for this case.
And I'll remove the call-in user. They're not responding.
All right, so can you put something in the chat, please?
Will do.
Thank you.
No reply, Chairman.
All right, thank you. All right, so let me call. So Mr. Cabrera, can you please spell and state your name for the record?
My name is Nicholas Cabrera, Nicolas. Last name Cabrera, and I'm the owner of Lostock Roasters.
This matter was being protested by ANC 6C. There is no one here. This matter was scheduled for a protest hearing at 10:30. It is now 10:48. The case was called, and there is no representation from the protestant group. So with that said, I'm going to make a motion that the protests be dismissed. Is there a second?
Ms. Quinn, I second.
You have a signed settlement agreement, so I don't know if that has anything to do with it.
You have a signed settlement agreement, sir?
Yes.
Was that provided to the agency?
I believe so.
All right. All right. With that representation, then, sir, I'm going to continue then Rather than dismiss the protest, I'm going to then continue this case to a date to be determined. I'm pending a settlement agreement being provided to the agency. So can you ensure, sir, that the agreement is provided to the agency as soon as possible?
Is there an email that you'd like me to send it to, or?
Ms. Oriana, can you please put the ABCA legal email address in the chat, please? There's the email address in the chat.
I will send it right away.
All right. Thank you, sir, for that representation. So you can send the agreement. So I'm going to continue this case to a date to be determined pending the receipt of the settlement agreement. All right?
Okay,
All right. Thank you, sir.
thank you.
All right. The next case in our calendar is case number 25 CMP 00069, the Little Gay Pub. Mr. Oriana, can you elevate the government and the licensee in this case?
Sure thing. Betsy McMullen, access elevated, and I believe that's all, Chairman.
Thank you.
Good morning.
Good morning, ma'am. Can you please spell and state your name for the record, please?
This is Assistant Attorney General Betsy McMullen, BETSY McMullen here on behalf of the district.
Good morning, ma'am. The licensee is not here, however, at show cause hearing status, there's no requirement for the licensee to be here. This matter then is scheduled for a show cause hearing on January 28th at 10:30 a.m. Just want to remind the parties that 7 days prior to the hearing, the parties are required to disclose documents and witnesses that will be relied upon in the hearing. Failure by either side to disclose documents and witnesses 7 days prior to the hearing, the board is empowered to prevent that side from relying on documents and witnesses that have not been timely disclosed. Any questions, ma'am?
No, sir. Thank you.
All right, thank you. All right. The next case in our calendar is case number 25-251-00023, Rose Bar, license number 77883. Ms. Oriana, can you please elevate the licensee in this case?
Sure thing. Richard Bianco, access elevated. That is all, Chairman.
Thank you. Good morning, Ms. McNullen. Can you please identify yourself for the record?
This is Assistant Attorney General Betsy McMullen here on behalf of the district.
Good morning. Mr. Bianco, can you please identify yourself for the record?
Yes, good morning, Mr. Chair, members of the board. My name is Richard Bianco, RICHARD BIANCO.
Good morning. Ms. McMullen, are there any preliminary matters in this case?
No, Mr. Chair.
Any in your part, Mr. Bianco?
None from the licensee, Judge.
Perfect. All right, then this matter is scheduled for a show cause hearing on February 4th at 10:30 a.m. Just remind the parties that 7 days prior to the hearing, the parties are required to disclose documents or witnesses that they will rely upon the hearing. Failure by either side to timely disclose the documents or witnesses, the board is empowered to prevent that side from relying on documents and witnesses that have not been timely disclosed. So I will see you then. If this matter is not settled, I will see you then on February 4th at 10:30. Thank you. Have a great day.
Mr. Chair,
Yes, ma'am.
if I could ask, we've sent OIC terms to Mr. Bianco. Could I just ask if we have the right email for him?
So I believe the OIC was sent to my client directly, but he has forwarded it to me, so I will follow up with, I don't know whoever counsel named on the OIC is. I'm not sure if it's you or someone else.
Great. I just wanted to make sure y'all received it. Thank you.
Whose case is this, Ms. McMullen? Is that Ms.
This is
Hogan
a-
Miller?
Yes, Ms. Hogan Miller.
All right. All right, so Mr. Bianco, that is Ms. All right. Okay.
Thank you.
Thank you. All right, then. Have a great day. The next case in our calendar is a public hearing on the Glover Park Moratorium Zone rulemaking. Mr. Oriana, can you please see if there is anyone online who wishes to testify on the Glover Park Moratorium zone rulemaking?
Sure thing. Jackie Blumenthal, access elevated. And I believe that's all, Chairman.
All right, thank you. Ms. Blumenthal, can you come on camera, please?
I'm trying to find out where to do that.
Okay.
You
Oh, I
see
see
a
it.
start video?
Yes, I got it. Thank you. Well,
All right.
yeah.
All right, good morning, ma'am. Can you please spell and state your name for the record?
Yes, good morning, Mr. Chairman and members of the board. My name is Jackie Blumenthal, Jackie Blumenthal, and I am representing ANC3B today. I am a former ANC representing the area of Glover Park closest to the commercial area. I was representing it for 16 years up until last year. No one else from the ANC was available and they asked me to fill in. So I hope that's appropriate.
That's fine, ma'am. Hold on 1 minute, please. Okay,
Mhm.
hold. All right. Good morning again. Today, the board is convening a rulemaking hearing to review ANC3B's request to renew the Glover Park moratorium and to add one tavern license to the moratorium area. Since 1994, a moratorium on the issuance of certain alcoholic beverage licenses has existed in the Glover Park neighborhood. The current areas of the Glover Park moratorium zone and the scope of the moratorium zone may be found in section 308 of Title 23 of the DCMR. The current moratorium zone extends approximately 1,200 feet from 2436 Wisconsin Avenue, Northwest Washington, D.C. 20007, which is located which is the location of the Wisconsin Avenue Imports LLC, trade name Pearls Wine and Spirits, holder of a retailer Class A license, ABRA license number 100880. Within the moratorium zone, the issuance of new nightclub, multi-purpose facility, and tavern licenses are currently prohibited. The moratorium zone does not apply to hotels or prohibit the transfer of licenses within the moratorium zone. This moratorium zone further prohibits the transfer of licenses from outside of the zone into the zone. The moratorium will expire on March 31st, 2026, if not renewed. The board will now hear from witnesses on the renewal of the moratorium and the ANC's proposal to add one tavern license to the moratorium area. The board will first hear from the ANC and then other interested parties. So go ahead, Ms. Blumenthal.
Okay, as I said, I represented this area for 16 years, so I've been involved in the renewal and extension of the moratorium since 2009. And every renewal, we have eased the moratorium, which started out as a blocking every license. We are now, as you know, down to limiting taverns and clubs. We have several concerns about why we're doing that. One of them is that we have a lot of established restaurants here, and we fear that the restaurants might switch their license to serve only alcohol and no food. We'd like to keep our restaurants, and we are working closely with them to help them sustain their existence in our neighborhood. We have the vacant properties that we have here are very large, and we fear that if a club were to come in and be successful in a large space, it could upset the very careful balance we've built over the period of time of moratorium to have a mixed-use neighborhood commercial center. We also have very limited public parking in our neighborhood so that people who come here to use the establishments frequently park in the neighborhood. And we do have some trouble with late night disruption as a consequence of that, increasing the foot traffic late at night for club business would would be disruptive. This is a very densely populated neighborhood. People live next to, near, across the street from, and behind all of our licensed establishments. The other concern that we have is that we are the home of one of the grandfathered adult entertainment clubs that is in a neighborhood. And while we have made our peace with it because it's not going anywhere, it does still provide disruptions at 3 or 4 o'clock in the morning. And we've had some violence connected with it in recent years. So there is a history of concern about clubs. As is our practice, we are giving, the ANC is giving weight to the people who live closest to the commercial area. We tend to think that people who are most involved in the issue should have weight on the issue. And the concern about lifting the moratorium, as I said, would be about clubs, disruption of the peace, order, and quiet, parking. But we are willing to try, as we have done for the whole extent of the moratorium, to ease it a little bit this time and see where we are in 3 years, which is why the request has said to renew it for 3 years and allow one tavern license, and see how that goes. So I think that's all I need to say right now, but I'm happy to take questions on this.
I guess just a question in general. When you said, so are you, when you said allow one tavern license, so is this to allow an establishment there to change from a CT to from a restaurant to a tavern, or is this to allow a new entity to come into the area? Which one is it that you're seeking?
I think we're open to either option. There is, the fear, given the fact that all restaurants are struggling right now, the fear is that if we had unlimited tavern licenses, it's possible that at least 2 or 3 of our restaurants might immediately stop serving food as soon as they could switch their license. We don't know. So we're opening up one license. Our idea to open up one license is to see if it attracts a new person, or if it causes a restaurant to want to become a tavern. And we're just fearful of having an unlimited number in the neighborhood, because it will, in our view, destabilize the peace, order, and quiet that we have managed to establish over the years.
No, you are aware that some restaurants have tavern licenses and they are truly restaurants, but they have a tavern license because by having a tavern license, you don't have to file the quarterly reports with the food. And are you aware of that?
Yes, I am, and our concern is that reason would make everybody switch, and then when they're not required to serve a certain amount of food, they won't, and then the food offerings in the neighborhood will go down, and we'll only have bar food available. But as I said, people are very tentatively concerned about this, but willing to be open-minded enough to try one for 3 years and then lift the whole thing in 3 years if that's what it comes to.
Now, and I don't have this information, and so do you know how many restaurant licenses are currently in the area?
I would guess somewhere between 10 and 15.
And then 15. Do you know currently how many tavern licenses, if you're aware?
We have no tavern licenses, and the only club license we have is the CX for Good Guys.
All right. So, all right. All right.
We-
And I'm sorry, ma'am. And go ahead.
I was going to say we had a tavern license, and it was one of the major disruptors of the neighborhood. So there is a little bit of history of concern, although that was a while ago.
All right. Thanks. Any questions by any I'm sorry, any questions by any board members? Any final comments you want to make, ma'am?
Well, we believe that the moratorium has really helped our neighborhood and it's kept it mixed use resilient. We've survived the pandemic with very little shutdown. Some of our restaurants have been here for 20, 30 years, 50 years even. And so we're really grateful for the moratorium to exist in that respect. And we are using it as best we can as a development and stabilizing tool for the commercial center. So we hope that you will listen to the neighborhood and extend the moratorium for 3 more years, and let us test out opening up a tavern license, one tavern license. Thank you very much.
You're welcome, and thank you very much for your presentation this morning. To represent on behalf of the ANC, the board will take this matter under advisement and will consider adopting a rulemaking at a future meeting. Thank you very much, and you have a great day.
Thank you.
Bye. All right, the next case is on case number 25-251-00019, Players Lounge, license number 1271. Is there anyone here for the Players Lounge?
Yes, we have David Bailey, access elevated, and Alicia Hogemiller, access elevated. That is all, Chairman.
All right, thank you. All right, Ms. Hogemiller, can you please spell and state your name for the record?
Good morning, Assistant Attorney General Alicia Hogemiller, ALYCIA HOGENMILLER, on behalf of the government.
Good morning. Mr. Bailey, can you please spell and state your name for the record? Mr. Bailey. I don't know what happened to Mr. Bailey. I saw him and then he disappeared.
Looks like connection.
Okay. Yes, Mr. Bailey. Okay, all right. Mr. Bailey, can you please spell and state your name for the record? Mr. Bailey. Mr. Bailey, can you please spell and state your name for the record, sir?
David Bailey, David, D-A-V-I-D, last name Bailey, B-A-I-L-E-Y.
And what's your relationship to this establishment, sir?
I'm the representing agent.
All right, Ms. Hogemiller, it's my understanding that an offer in compromise has been provided to the board for its consideration, and the board will review and make a decision on. Are you there, Mr. Bailey?
Yes, I'm here. I'm sorry.
Okay.
Yes.
And if the board will review this offer in compromise and make a determination whether or not it'll be acceptable on our legal agenda this morning. However, it's my understanding that you, Mr. Bailey, is asking that you want to make some type of statement. Is that correct, sir?
Yes, the owner of the establishment just asked that I can make a brief statement before the board reviewed the offer in compromise.
And what is the statement that you wish to make, sir?
Well, the owner just wanted me to state that. Well, first off, Chairman, thank you for giving me the opportunity to speak, and board members, thank you. The owner of the establishment is one of the establishments that let you all know. The establishment normally caters to it's like a neighborhood establishment, which normally caters to like a 40 and up type of venue, which normally they open up for lunch for like people in the neighborhood to come in and eat lunch. And then the evening time, people come in to eat dinner, and of course they will grab drinks at those times as well. They have been not in any trouble, so far as my knowledge, over the course of a period of time here. where incidents are occurring is like everyone there is kind of like your neighborhood establishment where everybody knows everybody inside. So the owner just wanted the board to understand that this isolated incident was not one that typically that they face on an everyday basis. And I can also speak as a former ABRA investigator that during my time as ABRA investigator, I've never had an issue with the establishment. Is typically, and from my knowledge, is normally catered to like my father's age. Like it's like an older crowd more so, where like I said, everyone in there kind of knows everyone, and like everyone's in like the neighborhood that just stops in, maybe grabs lunch or grabs dinner, and then goes about their way, maybe watch a game or something like that. But they do and they will provide security during the times when they have like a larger, when they're having like an event there or some type of special occasion where it's typically not more than like 10 or 15 people that normally typically in the restaurant at one time.
Is that it, sir?
Yes, Chairman.
All right. As I said before, this offer in compromise was provided to the agency. The board has moved this offer in compromise to its legal agenda, and we will consider the merits of the offer in compromise, and we will vote later on this morning whether or not we'll accept it. But thank you, sir, for the presentation that you made today. And
Thank you, Chairman.
as part of the record, Ms. Hogan-Miller, thank you. There's nothing for you to say unless you really want to say something.
The district would just ask that the board accept the offer and compromise as submitted. Thank you.
All right, thank you. All right, thank you very much then. Have a great day. All right, the next case on the calendar is case number 25 CMP 00062, Chicha Lounge, license number 125907. This case has been postponed to February 4th at 10:30 a.m. The next case on our calendar is a summary action in case number 25 ULC 00083, Lucky 7 Convenience and Tobacco. This is an unlicensed cannabis retailer. This hearing has been canceled due to the submission of an offer in compromise for the board's consideration and approval. That is the end of our morning calendar. And so we'll now move to our agenda items for the morning. The first agenda that we'll do today is the legal agenda alcohol. On the legal agenda alcohol, there are 5 matters. I'm going to review all 5, and then at the end, I will make a motion. Well, no, I'm sorry. You know what? Let me do these individually. So the first matter on this agenda is a review of a settlement agreement. This is for Philomena, license number, and this is in case number 2525 PRO 00125, license number 134142. This is Philomena. I make a motion that the settlement agreement be accepted. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 4-0. Number 2, review of a settlement agreement. This is in case number 25 PRO 00111. This is Lost Sock Roasters, license number 132428. I make a motion that the agreement be accepted. Is there a second?
Mr. Meadows, I second the motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 4-0. Number 3, review of a settlement agreement. This is in case number 26 PRO 00005. This is 29, license number 132387. I make a motion that we approve this agreement. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 4-0. The number 4 is a motion, a review of a motion for reconsideration. This is in case number 24 PRO 00075. This is B&B Convenience and More, license number 132583. Mr. Board Member Jones will not participate in this matter since Board Member Jones did not vote on the initial application. So the other 3 board members then should participate. So I then make a motion that we deny this motion for reconsideration. Is there a second?
Mr. Meadows, I second your motion.
Mr. Meadows, I second the motion. We'll have a roll call vote. Ms. Quinn,
I do not agree.
Mr. Meadows,
Mr. Meadows, I agree to deny the motion.
and Mr. Anderson agrees to deny the motion. So the motion, the board has voted 2-1 to deny the motion. Thank you. All right, number 5, review of a motion for continuance. This is Virginia Market. This is the case number 25 CC 00011, license number 119980. I make a motion that we approve this request. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones and Ms. Quinn second the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We now move to our legal agenda, alcohol addendum. Number 1, review of an offer in compromise. This is in case number 25251 00019. This is Players Lounge, license number 001271. The offer in compromise is as follows. Charge 1, allow the establishment to be used for an unlawful or disorderly purpose. Statutory authority, DC Code Section 2582382. There is a fine of $1,000 paid within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Charge 2, fail to follow security plan. Statutory authority, DC Code Section 25-82386. There is a fine of $1,000 paid within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Of the terms, the license shall submit a revised security plan in compliance with DC Code Section 25-836E within 30 days. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 4-0. Number 2, review of a request for reinstatement. This is for the Groove Lounge, license number 122135. I make a motion that we approve this request. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Anderson, I agree. The matter passed 4-0. Number 2, should I say it's dated number 3 too, but this is number 3 on the agenda. Review of request for involuntary transfer. This is the Groove Lounge, license number 122135. I make a motion that we approve this request. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 4-0. Number 4, review of cease and desist order. This is in 1865 Steak, Seafood, and Cigars. There's no license number. I therefore make a motion that we approve this order. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. We have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 4-0. And now let's do the licensing agendas. So this is the alcohol license agenda. There are 4 requests on this agenda. I will review the contents of all 4, make some recommendations, and then I'll ask the ABC board members to vote to approve the recommendation that's put forth by the chair. So number 1, review application for safekeeping of license. This is Quillix Restaurant and Lounge, license number 114288. Recommendation approved through March 31st, 2026. Number 2, review application for safekeeping of license. This is Flavorture, license number 121622. Recommendation approved through March 31st, 2026. Number 3, review application for Game of Skill, license and endorsement to place up to 5 consoles offering the game Firepot by Capital Games LLC. This is for St. Arnold's on Jefferson, license number 085989. Recommendation approval. Number 4, review request to withdraw the application for approval transfer. This is for Vint Marketplace, license number 129596. Recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendations as put forward by the chair for the alcohol licensing agenda. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We now move to the supplemental alcohol licensing agenda. Number 1, review application for streeter endorsement with 15 seats. This is for Joya Burger, license number 126641. I make a motion that we placard this matter. Is there a second?
Mr. Meadows, I second.
Mr. Meadows has seconded the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passed 4-0. We now move to the alcohol license cancellation agenda. The ABC board will be canceling the following licenses for the reasons outlined below. Giant number 2376, the license number 092843. The licensee requests cancellation. I therefore make a motion. The ABC board vote to cancel this license. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
and Mr. Anderson, I agree. The matter passes 4-0. We now move to our cease and desist agenda. The ABC board will be issuing orders to cease and desist the following licenses for the reasons outlined below. Chicha Lounge, license number 125907. The licensee's renewal application was dismissed. I therefore make a motion that ABC board issues a cease and desist order for this establishment. Is there a second?
Ms. Quinn, I second.
Ms. Quinn has seconded the motion. We'll have a roll call vote. Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 4-0. We now move to the board's temporary license and one-day substantial change docket. On this docket, there are 14 applications. I will review all 14, make some recommendations, and then I will make a motion and ask the ABC board to approve the recommendations as put forth by the chair. Number one is a request from Catherine Schmidgall, Schimidgall. She's requesting a one-day license class F for a film screening. This is January 29th. The license number is 134818, 120 attendees, 2 security guards, recommendation approval. Number two, a request from Madeline Perlman for a one-day license class F for fundraiser. This is January 22nd. The license number is 134968, 150 attendees, 3 security guards, recommendation approval. Number three, a request from David Stevenson for one-day license class G, Children's Winter Ball, January 17th. The license number is 134819, 150 attendees, 2 security guards, recommendation approval. Number four, a request from Justin Deckerbaum for one-day license class G, a wedding. This is January 18th. The license number is 134935, 170 attendees, 2 security guards, recommendation approval. Number six, number five, a request from Jessica Zaluk, Zaluzec, for one-day license class G exhibition. This is February 7th. The license number is 134941, 100 attendees, 2 security guards, recommendation approval. Number six, another request from Jessica Zaluk for one-day license class G exhibition. This is March 19th. The license number is 134942, 100 attendees, 2 security guard, recommendation approval. Number seven, another request from Jessica Zaluk for one-day license class G exhibition. This is September 24th. The license number is 134943, 100 attendees, 2 security guards, recommendation approval. Number eight, another request from Jessica Zaluk, a one-day license class G exhibition. This is October 2nd. The license number is 134944, 100 attendees, 2 security guards, recommendation approval. Number nine, a request from Alberta Williams for one-day license class G. This is a 90th birthday party. This is January 24th. The license number is 134961, 200 attendees, 4 security guards, recommendation approval. Number 10, a request from Whitlow's for one-day substantial change, soccer viewing. Nature of the substantial change, seeking to change hours of operation only to 7 a.m. for soccer viewing. This is January 17th. The license number is 082871. Substantial change license is 26SC 00505. Recommendation approval. Number 11, another request from Whitlow's for one-day substantial change soccer viewing. This is nature of substantial change, seeking to extend hours of operation only to 9 a.m. for soccer viewing, match viewing. This is January 24th. The license number is 082871. Substantial change license is 26SC 00506. Recommendation approval. Number 12, a request from CH Management Corp. Pub Crawl. The DC Whiskey Walk, March 7th. The license number is 105025. Substantial change license is 26 PCE 00001. Recommendation approval for 2,000 participants. Number 13, Reg Mo Promo Holdings, a pub crawl. The Lucky You Bar Crawl. This is March 14th. The license number is 104072. Substantial change license is 26 PCE 00002. Recommendation for 2,000 participants. And number 14, this is a retroactive matter. This is Berry Brothers and Rudd They're seeking retroactive approval for one-day substantial change. This was a wine tasting. Nature of substantial change to use premises to license off premises at 888 17th Street Northwest. This was January 13th. The license number is 131402. The substantial change license is 25 SC 00504. Recommendation retroactive approval. I therefore make a motion that ABC board members vote to approve the recommendation that's put forth by the chair for the board's temporary and one-day substantial change docket. Is there a second?
Mr. Meadows, I second.
Mr. Meadows has seconded the motion. We'll have a roll call vote. Ms. Quinn?
Ms. Quinn, I agree.
Mr. Meadows?
Mr. Meadows, I agree.
Ms. Jones?
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 4-0. So we now move to the board's alcohol license administrative docket. And on this docket, there are 12 license requests. And without objection, I make a motion that ABC board members vote to approve the alcohol licensing administrative docket for Wednesday, January 14th. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. We'll have a roll call vote. Ms. Quinn?
Ms. Quinn, I agree.
Mr. Jones?
Mr. Jones, I agree.
Mr. Meadows?
Mr. Meadows, I agree.
Mr. Anderson, I agree. The matter passes 4-0. And the last agenda for the morning, it is the medical cannabis licensing agenda. On this agenda, there's a review of a standard application for a new manufacturer's license, type 2. This is Alpha Processor. License number is 126728. I make a motion that we have a fact finding. Is there a second?
Ms. Quinn, I second.
Ms. Quinn has seconded the motion. We'll have a roll call vote. Ms. Quinn?
Ms. Quinn, I agree.
Mr. Meadows?
Mr. Meadows, I agree.
Mr. Jones?
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passes 4-0. We're now at the end of our agenda items for the day, and so therefore the board will be in recess until 1:30. I now ask all board members to return to executive session briefly. Thank you. Good afternoon. We're on the record. Good afternoon, everyone, and welcome to afternoon session of the ABC board. My name is Donovan Anderson, chairperson of the board. Joining me this afternoon are three other board members, Ms. Terry Janine Quinn, Mr. David Meadows, and Mr. Ryan Jones. The board does have a quorum with the four members here today. I just want the public to be aware that three members constitutes officially three members. As long as the board has three members in attendance, that constitutes a quorum, and we do have more than three members, so we have four members this afternoon. Before we get on the way with this afternoon's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There's 3 cases scheduled on our calendar this afternoon. Once your case is called, I will take a moment for IT specialists to elevate the right for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your cameras will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first hearing this afternoon is a show cause hearing, case number 25CC00011. Virginia Market, license number 119980. This hearing has been rescheduled to February the 11th at 1:30 p.m. The next case on our calendar is a qualifications hearing for Apple Dream Shop Columbia number 1, license number 130821. Good afternoon, Mr. Oriana. Can you please elevate the parties in this case?
Good afternoon. Ali Risky, access elevated. Supervisor Investigator Jason Peru, access elevated. And I believe that's all, Chairman.
I'm sorry?
I believe that's all. Nothing, Alicia Hogan Miller.
No, and I don't think this is the government.
Oh,
Day.
gotcha.
I believe there's an attorney for the licensee.
Yes, Meredith Kinner. Apologies. Access elevated. There's all, Chairman.
All right, thank you. Can the parties come on the camera, please? Good afternoon, everyone. Let me have the parties identify themselves for the record. We'll start with you, Ms. Kinner.
Yes, thank you. Meredith Kinner on behalf of respondent and the owner of the establishment who is here today. MEREDITHKINNER.
Good afternoon, ma'am. And who is the respondent and owner?
Ali Rizki, ALIRIZKI.
Good afternoon, sir. And just preliminary, Mr. Peru, you can introduce yourself for the record, please.
Yes, Supervisory Investigator Jason Peru with the ABCA.
All right, Ms. Kinner, this is a qualifications hearing. As you know, you receive a board order regarding the board's position. There was a summary suspension hearing on this matter. I believe that your client probably had paid there was a $10,000 fine because I think that they were operating illegally. And I guess what is your position regarding what's your position today regarding the hearing?
So just to be clear, there was a summary action closure in June 2025. At that time, my client was not licensed. I just want to be clear about that. He is applying for a license. So there was nothing that was suspended. Just to make that fact clear at the outset. I would like to actually make an oral motion, if that's possible, Chairman.
Go ahead, ma'am. What's that?
Yes, I would like to move for the qualification hearing and the proposed order of denial to be vacated. The order of denial and proposed finding of facts in that notice are based exclusively on the summary action, which was filed against respondent in June 2025. The summary action was resolved, as the board notes in its notice, via an offer in compromise, which was approved by this board in September 2025. This OIC included a $10,000 fine, as the chairman noted, which respondent paid the day after the board approved the OIC. Respondent has not violated the OIC. Respondent has not even had access to the premises without ABCA supervision since the summary action in June. There are no new facts outside of the summary action that would give the board a reason to deny respondent's license application at this point. In fact, to deny respondent's license application solely on the basis of the summary action, which was resolved by an OIC without any new facts, is tantamount to license double jeopardy. The respondent has already been held accountable for past violations and is being held accountable once again now for the same violations. The board intends to call witnesses such as Investigator Peru, SI Peru. We'd be happy to stipulate to the facts. As I understand, the facts are limited to those in the proposed findings of fact, and we will happily stipulate to those facts.
All right. With that said, Mr. Peru, thank you for being here today. There's no factual. We don't need to. There's stipulation with the facts in the summary suspension. So, you're relieved of you're responsible for this hearing. So, thank you for being here today, Mr. Peru. Okay.
Okay, thank you.
All right. All right. So go ahead. So I think that as far as the board's concerned, we do have. I think we'll take your motion under advisement. I'm not going to make a ruling at this juncture. So who was I guess maybe was it this? In alcohol proceedings, the board can look at your past action to see whether or not, if you have not complied with the law, to see whether or not, based on your prior action prior to receiving a license, whether or not you are qualified to comply with the law. And so we can look at the action of the owner in making that determination. I don't disagree with you that, okay, we had a summary suspension, the fine was paid, but is this the same individual who created this, who was responsible for the action? And how then can we trust this establishment, this owner, to give him a license if he has proven to us prior to that maybe he is not able to comply with the law?
Well, I would note that Mr. Risky may be the owner. He was not, in fact, the employee that was involved in the illegal activity, nor was he at the premises at the time. The employee's last name is Ali. So if there's some confusion about that, that may be understandable. Mr. Risky has not been licensed by this board yet, and I would ask for the opportunity for the board to allow him to comply with the terms of the OIC. The summary closure is still in effect. So he has not had unsupervised access to the premises. He's paid the fine. So he's done everything up until this point, including build out and things of that nature, to become licensed. And so now to say you can't become licensed, we're not even going to give you an opportunity to show us that you can comply with the OIC, just seems unduly punitive. And, I think denying his license application based on what is speculation, I don't think that's appropriate. He's complied with the OIC. He hasn't violated the OIC. There are no new facts which would which would tend to say that his character was less unfit now than it was when the board approved the OIC. The board also didn't include any conditions or remediation provisions in the OIC. In fact, one of the terms is that the OAG would not oppose the lifting of the summary closure once the respondent is licensed. So it seemed that the OAG was acknowledging that the respondent would at some point be licensed, and if they'd shown they were in compliance with the OIC and had done all the other things that are necessary to become licensed, that they wouldn't oppose having that summary closure lifted. In fact, it says the district, which I think would include the board and not just the OAG. So I guess I'd be happy. I think if you have any specific questions for Mr. Risky, he's here. I'd be happy to also address any specific questions about the applicant. But again, I think that to just kind of contravene the explicit terms of an OIC really devalues and undermines the purpose of the OIC, and I think would send the wrong message to future applicants who may have made a mistake in the past. That if, you can enter into an OIC because you understand that what you did was a violation of the law. You can pay the fine and comply with all the terms that you can until you're licensed, right? And it doesn't matter because the board can still deny your license. So I guess I just think that really devalues the whole process. It is not sending a message. I mean, of course, if the board were to approve a license, Mr. Risky and the respondent would be subject to all of the same regulations and law, the regulations and laws that the board can enforce. If the respondent were to sell unlicensed product like some other licensees have done, the board could revoke the license. They could suspend the license. You could put conditions on the license. There are several things that can be done if there is continued illegal activity. The board has several options, but there hasn't been since the board approved the OIC. All Mr. Rizzi has done is comply with the OIC. Again, if you have any further questions,
No, I have some questions. Questions that I will ask that either your or Mr. Rizzi can respond to. And I guess maybe Mr. Rizzi can just give us some background about his who is he? I mean, what type of background does he have to run this type of business? I mean, maybe that as a start. I mean, we can have that maybe he can share that with us.
Okay, I'm Ali Risky. I'm 36 years old. I used to run the Apple Dream Shop Colombia until June 2025. And after that, I comply with everything that they told me to do. I fixed the shop. I paid the fine. I sent the employees. I did the camera security. I did the ADT check security as well.
Well, I guess what I said is just tell us who you are. Like, I mean, and just who are you? Tell me a little bit of your background. I mean, what background do you have in running this type of business? If license is to be granted.
I'm a father of two. I'm a hard worker guy. I'm very honest.
Were you born here?
No, I wasn't born here. I was born in Morocco. I moved here in 2008. I started working at hotels and restaurants. After that, I did Uber for almost like 6-7 years. Never had any criminal history or anything. I said my background is clear. I just want to do a good job and take care of my family.
I guess let me ask you a question, and I mean, I'm just asking a question just for background information. I mean, was this an I-71? Was this an I-71 business?
Yes.
And how long was this establishment in business?
since 2023, I think December or January 2024.
So I guess I'm just, and I'm not, this isn't a got you. I'm just trying to get some background information because since this is not a got you, so you're not under oath currently.
I would.
You're not under oath
This
currently,
is
so I'm
outside
not.
of the scope of the proposed facts. Just, yes.
I am trying to,
Understood.
as I said, this is a qualification. This is. I don't know this. I don't know this. I have some questions to ask, and I don't know who he is. So I'm just trying to get some background information from my own benefit. I know what the facts. I know what the facts state. I am just trying to find out. Just that. And I guess one of the questions I have is that okay. Your business you operated. You apply for a license. So if you
Yes.
apply for a license, so why did you believe that you can continue selling if you weren't given a license? I mean, and I'm using this as for example, you apply for a driver's license. You can't go drive a car because you have not been given a driver's license. So if you apply for a driver's license to drive, why then did you believe that I can go drive this car? So the issue is that you were operating, you were given a stream to apply for a license, and so you're given you apply. A lot of establishments did not apply for a license. You did, and so since you apply for a license, why is it that once you apply for a license, were you not aware that you could not continue selling because you're now applied for a license? And you can advise in whichever way Miss Kenner. I'm not gonna prevent you from doing your job, ma'am. So if you don't think that's the question he should respond to, you can.
I mean, I think that I can speak in my conversations with Mr. Rizky that he understands that what happened at the shop in June should not have happened, and that
Yeah.
as a licensee, he has to follow the rules and regulations that the board enforces. I think, he went through in my discussions with Mr. Rizky, he went through the the certification permit provider training. So he's done kind of that first step training. Has all his supplemental documents in. He's ready to have Jason come out, or excuse me, SI Peru come out and perform that final inspection. He's invested money to get to that point, including paying rent the entire time the premises has been closed. SI Peru hasn't responded to his inquiry about a final inspection since October. And so, I guess I'm also kind of wondering about the timing, because since October, Mr. Rizky has just continued to pay rent and invest money now, reasonably relying on the OIC terms, and the fact that he'd complied with them thus far. And now to have the license potentially be denied, it really feels,
So
yeah.
When was the OIC? I don't have it in front of me.
The
When was
OIC was executed. It was signed on September the 15th, and the board approved it on September the 17th. There are a couple, terms that I think relate directly to licensing, including that the OHE agreed that the district would not oppose. In fact, they waived the district's right to oppose the motion to lift the summary closure, which Mr. Rizky could only apply for once he had a license. He can only get the summary closure lifted once that license is in place.
All right. Okay. You have now answered the question I was about to ask you. So, the employee or employees who committed that infraction, is this person or persons, are they currently a part of the team?
No, sir.
Licenses are granted?
No, sir.
And Mr. Rizky has already been in the process of registering some of the employees. His licensing specialist hasn't processed those registrations yet because he hasn't been had, hasn't been through this process yet. So, but yeah, that's all new employees. Everybody's going to have the training that ABCA requires. And he'll run a compliant facility.
All right, so what is it? What mitigating precautions has the owner put in place to ensure that such an action will not occur again?
Is that for me or for Mr. Risky? I'm sorry.
Whoever can answer the question, ma'am. I'm being flexible since there's an attorney here, ma'am.
Specifically, and I would add that English is not Mr. Risky's first language, so I do appreciate you allowing me to answer in his behalf, to some degree. I mean, I would say first and foremost, everybody's going to have to do the required training, and I think that training, really highlights the dangers of diversion and the consequences, as well as, we will continue to work with the applicant. And so if there are questions about compliance, they'll be able to consult with counsel during that, after licensure and before they become operational. I know that, Mr. Risky, one of his managers is also a manager at another location, to my knowledge, or is an owner at another location. And so that person already had a licensed location that is in good standing. So that person has that knowledge on how to run a licensed facility. So, if that answers your question, Chairman.
All right, so you just touching a question I was about to ask. So is Mr. Rinsky the 100% owner of this? If this license is he the 100% owner?
He is, yes.
And so who's the management team who's the management team who would operate this facility?
It's not finalized yet, but they may they may have a manager who is also a manager at another facility. If there were to be a management agreement, that would of course be submitted to the board. That is, Mr. Risky will have experience to fall back on, whether it be through counsel, or potentially relying on this manager who has experience. And not that Mr. Risky isn't more than capable of managing on his own, but if there were to be questions, he would have those resources.
Does ownership understand that it can only distribute, store, and sell medical cannabis products provided by DC licensed cultivation centers and manufacturers?
Yes, sir.
Does the business have any Schedule I substance in its possession, either on site or at another location?
No.
Does the business have any non-medical cannabis products in its possession, either on site or another location?
No.
Does the business understand that the presence or distribution of Schedule I or non-medical cannabis products may lead to the closure of the business or revocation of the license if it's issued?
Yes, sir.
Any questions by any board members? Go ahead, Mr. Meadows.
Yeah, just one quick question. When the OIC was signed in September, there was no agreement with the landlord or involvement?
That's correct, because the applicant intended to stay at the premises. The landlord was not involved in the OIC. Their lease wasn't terminated.
Okay, and
we didn't represent the landlord, so I'm just speaking. I don't believe that. Obviously, the landlord was served. I don't know that they ever reached out to negotiate an OIC or anything of that sort.
And Mr. Ritsky testified he's the 100% owner of the Apple Dream. The Lala Juice Corp, is he also the 100% owner of that?
Yes, Lala Juice Corp is the applicant name, that the
Yes.
trading as Apple Dream.
Okay, thank you. Thank you, Mr. Chairman.
Any other questions by any board members? Um, any, Ms. Skinner, any final comments or questions?
No, I would, I understand the board's, concern potentially about unfitness, but I would say that Mr. Risky is more than ready to accept the responsibilities that come with the privilege of licensure, which includes obviously first and foremost complying with the law. And again, he has not violated any of the terms of the OIC, which will continue to remain in effect, in addition to the other mechanisms that the board has should there be future violations. The OIC will also be in effect. So he is still bound by that also to not engage in illegal activity. So I would ask the board to I don't know if I can ask the board to deny its own proposed motion, but I would ask the board to vacate the proposed order of denial and to allow Mr. Risky and the respondent to proceed with licensure.
All right. Since this is a formalized hearing, so let me end this. Let me end this in the formality that it was presented as chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia in accordance with DC Official Code Section 2-571 of the Open Meetings Act. I move that the ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on disqualifications hearing for Apple Dream Shop, Columbia #1, license number 130821, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon on disqualifications hearing regarding Apple Dream Shop, Columbia 1, license number 130821. For the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. The matter passed 4-0. The board will issue a decision on what direction we're going to ask the agency to take regarding the issuance of this license and the issuance, or on your motion regarding the board order regarding the purpose of this hearing today, ma'am. Okay. Thank you for your presentation. And thank you, Mr. for being here today.
Thank you.
All right. Thank you. Have a good one.
Thank you.
All right. Oh. All right. The next case on our calendar is case number 25 PRO 00082, SETA Oasis, license number 129034. Ms. Oriana, can you please elevate the rights of the parties in this case?
Sure thing. Jeff Jackson, access elevated. Adam Kadir, access elevated. Investigator Mikey Nelson, access elevated. Melissa Swaby, access elevated. Jeffrey Green, access elevated. And Joshua Leland, access elevated. That is all, Chair.
All right, thank you. Can I have everyone on camera, please? All right, Mr. Jackson, can you identify yourself for the record, please?
Yes, Jeff Jackson, JEFFJACKSON, representing the applicant.
Who's the applicant?
So Siesta Oasis.
And who do we have here representing the establishment today?
Melissa Swaby.
Okay.
Oh, sorry
Go
about
ahead.
that.
Spell and state your name for the record, ma'am.
My name is Melissa Swaby, Melissa, Swaby, SWABY.
All right, good afternoon, ma'am.
Good afternoon.
Let me see. Who is the protestant? I'm sorry, Mr. Is that you, Mr. Kadir?
Yes, I'm the lead protestant.
Can you spell and state your name for the record, please?
First name Adam, Adam. Last name Kadir, Kadir.
All right, good afternoon, sir. All right, Mr. Jackson, and I'm just gonna go a little bit out of order, but this is this establishment already has an entertainment endorsement, but I guess they're asking for a cover charge, and I guess maybe dancing. So maybe you can give me some clarification. I mean, because I read the case report, but I'm somewhat confused. So do they plan to create a dance floor in the establishment or what? Explain that to me, sir.
Yes. So what they plan on doing, they wanted to have a cover charge and dancing because they was having fundraisers for their countrymen out of Jamaica. So it's not really creating a dance floor. It's already a floor created. So they would just remove some of the tables and chairs and move it back so people can dance. And it'd be on the second floor, would not be in the restaurant area. They have two floors. Restaurant area is on the first floor. And on the second floor, they have an open area where you can also have food and entertainment. So everything would be conducted on the second floor.
All right, so they are creating a dance floor then. So they're moving furniture. They're moving furniture to create, although you might not install a dance floor, but what you're saying is that a furniture has been moved so people can dance in a specific area.
Yes, sir.
All right. Mr. Kadir, is there? I read your PIP, and I'm trying to find out, is there anything short of going through this hearing? Can this matter be settled? Is there anything that is there a way this board can be involved in coming up to any type of agreement that would be acceptable to both parties in regarding this substantial change with for the cover charge and the dance floor?
Are you asking for my prepared testimony, or are you asking for our proposed what we would want?
No, I'm trying to see if this matter can be settled short of going to a hearing. Is there something that we can agree to? Is there something that we can agree to, or do we have to go to a hearing? So I'm not asking for your prepared testimony. I'm just saying I'm not quite sure. What is it that the protestants want?
We want our protest is based on 4 points: the noise, the crowds, unlicensed activities that have been occurring, and respect for quiet hours. We believe, I'm sort of summarizing some opening statements in my testimony, we believe that the proposed changes will exacerbate all of these problems that are currently occurring in our community as a result of the establishment's operation.
I'm asking hold on. I'm asking a different question, sir. I'm not asking you what your case in chief is. I'm asking you a question. Is there any type of proposal that can be put?
Yeah, sure.
And if we can, we'll do this. If not, we'll go through. You can present your case.
Sure.
And the board will make a decision whether or not we're going to issue this. So that's what I'm saying. Yeah. What is it that you would want to if the what would satisfy the protestant to grant this cover charge and dance floor.
Yes, sir, I understand. Thank you. In short, having absolutely no noise coming from the establishment, audible outside of the establishment, in adjoining or nearby homes, including those of some of my other members of our protest group. So that addresses point number 1 on noise emanating from the establishment. Number 2 on crowd control. We believe that as there will be a cover charge that involves people lining up, that involves people coming to the establishment. And so I'm not exactly the expert on this issue, but some sort of strategy that is approved and enforced by the board, or something that ABCA is able to check on regarding their use of public areas for crowd control, and customers or potential customers to the establishment using public areas and sort of the business, I guess, spilling out onto public areas because there will be more people coming is the idea, I suppose. And some people will have to wait outside as there will be a cover charge and a line. With regards to quiet hours, that relates to the noise as well. And that is simply a matter of being responsive to their community. When it's quiet hours in the neighborhood, when their noise is affecting other people, to respond to us and not hang up the phone on us. Or yell at us over the phone before hanging up on the phone on us, and respect their community.
Mr. Chairman, may I add?
Yes, Mr. Jackson.
Yes, so the applicant was willing to, first of all, a sound test was conducted by by ABRA investigators, and we had came to the sound test report showed that if the noise level is kept at a particular level, it cannot be heard emanating outside of the establishment, and that's on record inside the report. So the applicant agreed to maintain that sound level. Also, the applicant is not having dancing and cover charge nightly. It was only for like certain things, like if someone wanted to have a fundraiser, also if someone wanted to have a bachelorette party. So it's not like they're going to have a cover charge and dancing nightly. And we also suggested and recommended that it would be on occasions. So it won't be every night, and it won't be sound emanating because of the sound test, and we agreed to abide by the sound test that was conducted by ABRA. And as far as the lines outside, we had suggested that there would not be any lines because people would be able to walk right in, and there's a separate entrance from the restaurant to get to upstairs.
I'm sorry, who is Mr. I'm sorry. Who is Mr. Green, Mr. Jackson?
I don't know, Mr. Green. I guess he's one of the. Where you see Mr. Green?
Okay, I'm sorry. Only Mr. Jackson and Mr. Kadir are able to speak. Okay, so Mr. Green. So I'm speaking to the representative at this juncture. Okay, so I'm only speaking to those folks at this juncture. I mean, if you are listed as a witness, then if we go through this hearing, then you can express yourself when we get there, sir. Okay, so could put your hand, lower your hand, please, sir. All right, so I guess Mr. Kadir, what Mr. Jackson stated, that's not workable for you.
No, the sound test. I mean,
we're not gonna let's do the hearing because our time okay. Is up, and so all right, so all right. So we're gonna do this protest hearing, and we're gonna complete this today. I need everyone to be mindful. So let me ask you. All right, so basically what's going to happen is that the parties will have an opportunity to do opening statement. After the parties have done opening statements, then the board will call its witness. The board will ask questions of its witness. And once the board has asked questions of its witness, the protestant will have the licensee would have an opportunity to ask questions. Then the protestant ask questions. And then after that's done, then the licensee will present its case. Once the licensee has presented its case, then the protestant will have an opportunity to present its case. We do closing out arguments, and then the board will take this matter under advisement whether or not we'll issue or deny the issuance of this endorsement. Okay, so Mr. Jackson, you can start off with your opening statement. Basically, tell us what it is that your client is seeking.
Yes, good afternoon, everyone. Jeff Jackson here. My client is seeking to allow the application to proceed to allow cover charge and dancing.
What is it that why is it that the licensee is requesting for this specific? What is it? Why is it licensee requesting this change?
The reason why the licensee is requesting the change is, I don't know if you're aware, but a lot of restaurants in the DMV is closing and they don't have a lot of customers coming inside the establishment. So it's another way to generate some revenue, and it's allowed them to have fundraisers at times and to also have individuals come there if they want to have a party, like for example, a birthday party or some sort of social gathering at their establishment. So it's just another way to have some additional income coming in to the establishment.
All right, Mr. Kadir, do you wish to do an opening statement now? You can defer to you present your case.
Yes, thank you. Good afternoon and greetings to the member of the board. Thank you for meeting with us today. My name is Adam Kadir. I'm the primary protester on the petition against SETA's application number 25 PRO 00082. I live at 3811 Georgia Avenue Northwest, and I share a wall of my apartment with the upper story of the applicant's business. I am a teacher at a public school here in DC, and I'm attending also graduate school at the same time. Our protest to the proposed modifications is founded on 4 points: noise emanating from the establishment, crowd control in public areas around the establishment, unlicensed activities in the establishment, and respect for quiet hours in the neighborhood. I plan to show in my testimony that, based on the behavior of the applicant since they opened in March of last year, the proposed modifications to allow a cover charge and add a dance floor will have negative effects on our community's livability and peace of mind. What the applicants are attempting to do is inappropriate in their space and location when they are surrounded by residential properties on all sides. We want to work on solutions to these issues, as we tried to do during both mediation hearings. As I go through my testimony, I will propose solutions or ask the board for help in instituting conditions on the approval of the modifications based on solutions that work for the community. The first and most important issue is the noise. The level of noise insulation in the establishment is currently simply not sufficient. Speaking personally, I can hear it through my walls at basically all hours of the night. As I was writing this testimony on a school night at 10 p.m., I could hear woos through the wall on a karaoke night. Any amplified music that is played in there, any DJ set, any live band, any karaoke, any stand-up set, even a loud crowd on a given night, I can hear in my home. It rattles my walls, it keeps me up and wakes me up at night, and it disturbs my peace of mind in my own home. Just last night, I could hear it through my walls until at least 11:50 p.m. when I was finally able to fall asleep. This meant that I got 6 hours of sleep before needing to go and teach school children. As the protest report shows, the establishment has historically been a restaurant, despite the immediately previous occupants of the space not operating in this manner. The sound insulation may be sufficient for a quiet restaurant, but for a, quote, restaurant hosting DJs and live bands and hosting bachelorette parties and birthday parties, it is just not enough to maintain respect of neighbors, not only myself, but others as well. This establishment is licensed to operate as a restaurant, not as a nightclub. I want to be clear. I acknowledge that our protest is against the proposed modifications to the license, not to the establishment itself. SETA is there, and we are not asking for them to close or for the board to revoke their existing licenses. But proposing to add a cover charge and add a dance floor will only have the effect of amplifying the music and the crowds. In particular, I refer to the DC Code Section 25-313, Appropriate Standards, which reads that, quote, in determining the appropriateness of an establishment, the board shall consider all relevant evidence of record, including, number 1, the effect of the establishment on real property values, number 2, the effect of the establishment on peace, order, and quiet, including the noise and litter provisions set forth in sections 25-725 and 25-726, and number 3, the effect of the establishment upon residential parking needs and vehicular and pedestrian safety. And so End quote. So we ask that the applicants respect their neighbors in the operations and that the board consider the effects of that the proposed modifications will have on the community. The board must not let SETA go forward with these modifications without mitigating the sound in the establishment by installing actual soundproof insulation and drafting a crowd management strategy to manage patrons outside the establishment. I ask the board to condition their approval of SETA's application on making these changes. This is not a nightlife district. Is it so unreasonable that the applicants make basic accommodations for their neighbors, given the kind of neighborhood that they operate in? Yes, I have been told many times throughout this process, this block is zoned for mixed use, but it is still not a nightlife district. It is clearly not a nightlife district. This is mentioned nowhere in the planning documents for these few blocks of Georgia Avenue, NMU-7B-GA, referred to in the protest documents. This is not Logan Circle or U Street or 18th Street in Adams Morgan. The applicant's current operations are not appropriate for their location because although this side of Georgia Avenue is zoned for mixed use, the surrounding blocks are not, and the operations of the applicant affect all the homes who look into the alley between Georgia Avenue and 8th Street, not just their immediate neighbors like myself. Dozens of row homes and apartments look into the same alley and can hear the noise and are also affected by the crowds. Let me explain just how this is not a nightlife district. Let's take a look at the few blocks surrounding the applicant and our homes, as given in the protest documents. I know this area because it is my home. Am I allowed to share my screen with the meeting?
This is an opening statement, sir. We don't do that. When you're testifying, you can do that. This is just your opening statement,
Understood.
sir.
So if you were to look at the map showed in the protest document, in the protest report, on the same block as the establishment, you have one other open business, a liquor store that remains closed most of the time. There are two empty storefronts, one next to the establishment that housed a marijuana dispensary until this past summer, and a space at the intersection of Georgia and Randolph that has stood empty for several years. The entire rest of the block is residential. On the same block across the street, the only business is Safeway, and then you see two large residential apartment buildings. The remainder of the entire square block around the applicant is residential. Randolph between Georgia and 8th, residential. 8th between Randolph and Quincy, residential. Quincy between 8th and Georgia, residential. You see several large apartment buildings on these blocks, including the new Quinn Apartments on Quincy. Two sides of that building face the alley that the applicant looks onto, which means that they can hear everything that I can hear coming out of the back of the applicant's business. On the block south of the applicant, other than the George Avenue Petworth Metro Station, you see entirely retail. A nail salon, a Metro T-Mobile store, a fragrance shop, a convenience store. One of the other lounges listed in the protest report as being on this block, Husporia, as I think it's pronounced, closed since the documents were compiled and now lies empty. Across the street, in addition to another entrance to the Metro, you have a Dunkin' Donuts, a Subway, a Thai restaurant, and a burger restaurant, all retail. On the block north of the establishment, you have several empty storefronts, some residential, a salon, a yoga studio, an insurance company, a tax office, a bar, a medical marijuana dispensary, a dentist, an e-bike rental store, a barbershop, a pizza and ice cream restaurant. On the other side of the street, there's a Wendy's that's been closed for renovation for almost 2 years, and the rest of that block is also entirely residential. In short, you would have to go several blocks north and east to the Upshur Business Corridor if you want to find two potential nightlife establishments side by side, even two restaurants side by side anywhere nearby. I strongly support building more development in DC and expanding our opportunities for going out and opening small businesses. But the fact is that these few blocks, despite having some nightlife several blocks north and south, do not make up a nightlife district. You do not see people bar hopping from one place to another, ending up at the applicant. You do not see crowds looking for a place to go, waiting outside of the applicant. The applicant is smack dab in the middle of residential with some more distant retail. I hope I have sufficiently established that this community is not a nightlife district and that those of us who live here did not sign up to live in a nightlife district. So let's talk about the principal objection to this application, the noise. It was agreed at the first mediation hearing that ABCA would conduct...
This is an opening statement. An opening statement is just this is not you presenting your whole case, sir. Okay, this is just an opening statement.
I have an hour and a half, don't I?
Sir, you don't have an hour and a half to do an opening statement, sir. An opening statement.
I was told I have an hour and a half.
Mr. Kadir, you do not have. First of all, this is not. You're just doing an opening statement, sir. An opening statement is that you're telling me what your case is and who the witnesses you're going to call and what they're going to testify to. You're not presenting your case here, sir. When you present your case,
I can pause there and continue. I understand. Thank you.
But I'm just saying to you, this is just an opening statement. You're just giving me an overview You're gonna call and what it is. One of the things I also want you to be aware of, sir, is that you do live, you're talking about a night like you, for you particular, from what I read from the report, you do live in a mixed use area. So it's a different, when it comes to noise, the rules are different for you than for your other neighbors who live in residential. Okay, I just want to say that. Okay, so I know you're talking about because you talked about the fact that you're hearing these noise. You live, I think you share a wall, I think, with the establishment from what I read in the report, and I think that's what you stated. You are in a mixed use area. So the rules the rules regarding noise is different for you than for the other neighbors who live in a strictly residential area. I just want to, and I think you're aware of that because I think you talked about the regulations, but there are exceptions for people who live in a mixed use area rather than a residential area. Okay? All right, fine. So the way this, so you've done your opening, the board is going to call its witness. And so the first witness that we're going to call is Miss Makia Nelson. She will testify. I'll ask questions of the reports. Once the board asks her questions and the board member, I'll ask her questions and the other board members will have an opportunity to question her. Mr. Jackson will have an opportunity to question you, and then you'll have an opportunity to ask her questions of her report. Okay, sir? Everyone aware of the process that will follow, okay? And so you're not going to present your case until the board has presented its case and the licensee has called his witnesses and presented his case. And then after that, you'll have an opportunity to present your case. Okay, sir? All right.
Yes, thank you. I'm sorry. I misunderstood the proceedings. I thought that my opening statement was part of my testimony. Thank you.
No, sir. Your opening statement is not part of your testimony, sir. Your opening statement is just because if you're going to testify later on, I'm going to swear you in, and then Mr. Jackson will have an opportunity to cross-examine you, and the board will have questions of you. Your opening statement is just that you're just giving us an overview of your case, and then once you start calling witnesses, either yourself or other folks, then they'll be under oath, and then Mr. Jackson will have an opportunity to cross-examine them, sir. Okay?
Understood. Thank you.
All right. Ms. Nelson, can you raise your right hand, please? Do you swear or you need to unmute your line, ma'am? Do you swear or affirm to tell the truth and nothing but the truth?
I affirm.
Can you state and spell your name for the record?
Makia Nelson, that is Mikea, last name Nelson.
And where are you currently employed?
The Alcoholic Beverage and Cannabis Administration.
How long have you been employed at this agency?
Approximately 7 years.
And what are your duties and responsibility in working for this agency, ma'am?
I conduct inspections and investigations of ABC licensed establishments within the District of Columbia.
Are you familiar with this establishment, Feta Oasis, with the purpose of this protest here today?
Yes, sir.
And how did you become familiar with this establishment?
I was assigned the protest investigation of substantial change application for Set Oasis.
Did there come a time that you write a report?
Yes, I did.
Do you have the opportunity to share your report with the board or with this hearing?
You said, do I have the opportunity to?
Are you able to share your report, share your screen with your report, ma'am?
Yes, if you give me just a moment to pull
Ms.
that up.
Doriana, can you please give Ms. Nelson the ability to share her screen?
Access granted.
Thank you.
Give me just a moment. Sorry, I'm having a bit of an issue with the sharing. Here we are. Are you able to see?
No.
Okay.
Okay. Can you identify the document that's on the screen, ma'am?
This is a protest report for the substantial change application for Zeta Oasis.
And what's the protest issue?
The protestants are protesting the establishment having a dancing and cover charge on the grounds of peace, order, and quiet, as well as vehicular traffic and pedestrian safety and parking.
Did you have an opportunity to speak to the parties?
Yes, I did.
And who did you speak to?
I spoke with Mr. Adam Kadir, representative for the protestant. I also spoke with Mr. Jeff Jackson, representative for the licensee, as well as Mr. Swaby, owner of the establishment.
And what information were you able to gather from the applicant when you interviewed them?
I gathered that the applicant had issues with peace, order, and quiet, specifically noise emanating
No,
from
the applicant.
Oh, I'm sorry. The applicant advised me that he has a small restaurant that he is looking to offer cover charge and dancing to supplement income for his employees. He said that he was not quite making enough money to keep the establishment open and to pay the neighborhood employees as he would like. He stated he does not offer entertainment on a regular basis, but offers it on Friday and Saturday nights, which includes trivia nights, live bands, karaoke, etc. The licensee also advised me that he is willing to work with the establishment to mitigate noise issues by installing soundproofing, as well as being receptive to their complaints. However, the protestants were not open to coming to a settlement agreement or an agreeable volume of noise.
What information, if any, were you able to gather in speaking to the protestant?
I gathered from the protestants that there are issues with noise emanating into their homes. Also, they have issues with crowds gathering outside and leaving behind trash in front of residential areas. There is a light behind the establishment that flashes between red and blue lights that emanate into residents' homes that disturbs their sleep. And they believe that adding these two endorsements will cause the restaurant to operate in a nightclub and will exacerbate the noise issues that the residents are currently experiencing.
So tell us about the characteristics of this neighborhood.
The establishment is located on the 3800 block of Georgia Avenue, which is a neighborhood mixed-use zone. The zone allows for establishments to share vertically with residential areas. That particular block has a mix of apartments as well as residential houses. The surrounding areas, Randolph Street, Quincy Street, and 8th Street Northwest are all residential areas. That particular the 3800 block of Georgia Avenue has high vehicular and moderate pedestrian traffic during all hours of the day. The Metro Center is approximately 2 blocks away, so you have people commuting to the neighboring grocery store as well as the Metro and neighboring restaurants that are in the area. The establishment specifically is a 2-level brick front restaurant with a summer garden that is enclosed in its rear.
All right, let's see. How many ABCA licensed establishments are there within 1,200 feet of this establishment?
There are approximately 8 ABC licensed establishments within 1,200 feet.
What are the current hours of operation for this establishment?
This establishment is licensed to operate between 4 p.m. and 12 a.m. Monday through, Thursday, Friday and Saturday from 4 p.m. till 2 a.m. and on Sunday from 12 p.m. until 12 a.m.
So what are the hours of alcohol sales?
The hours of alcohol sales are Sunday, 12 p.m. to 12 a.m., Monday through Thursday, 4 p.m. through 12 a.m., and Friday and Saturday, 4 p.m. through 2 a.m.
Is the substantial change, are they trying to change their hours?
No, sir. The applicant is for only dancing and cover charge endorsements.
Right. Was did the agency have an opportunity to visit yourself or any other investigator have an opportunity to visit the establishment during this period of this protest?
Yes, we visited approximately 13 occasions.
And what is it that tell us what information, if any, was the agency able to gather during these visits?
During these visits, we have gathered that the establishment offered ticket sales on Eventbrite online. However, on two of the visits, an investigator entered the establishment in an undercover capacity to determine whether the establishment was requiring cover charge for entry. During both of those visits, the investigator was not prohibited entry prior to paying. They were allowed to go in the establishment and to dine. However, to visit a particular area of the establishment, a cover charge or ticket was required prior to entry. Additionally, we monitor the establishment both in the mixed-use zone and the residential zones, and no investigators were able to hear any noise emanating from the establishment into residential areas.
You heard Mr. Kadir talked about noise in his establishment, in his home. Are you able to did ABCA do any type of visits to address this issue?
Yes, I have spoken with Mr. Kadir and I have personally paid visits. Unfortunately, per our law, we did not go inside of Mr. Kadir's home to establish any noise violations due to him residing in a neighborhood mixed-use zone. However, we did visit the establishment and make the owner of the establishment aware of the complaints and asked him to lower the music while we were still present on site.
Now, are there any did the agency do any type of noise tests regarding during this investigation?
Oh, yes. We did do
Where is that in your report? And just talk about that.
Yes, sir. That would be page 9 of my report, and I'm happy to scroll to that page if you would like.
Yeah, go ahead, please.
Per the request of the licensee, lead investigator Playtest and I conducted a sound test of the establishment with the protestants and this required for lead investigator Playtest and I to be inside of the resident's home, in which we entered Mr. Jeffrey Green's home, who's located in a residential area, and I remained inside of the establishment. During that time, the establishment played music at various levels, so we can see if investigator Playtest could confirm that she heard noise emanating from the establishment into a neighboring resident's home. The licensee brought a live band to conduct the sound test. During that time, the band played at a variety of volumes. to which investigator Playtez was only able to hear or substantiated that she heard noise from the establishment when the band played at the loudest possible volume without destroying their instruments, or so I was advised by the band.
So how many different tests, if any, did the agency conduct?
There was one sound test conducted.
All right. Was the agency, what's their investigative history regarding noise, if any?
The establishment has received a total of 20 complaints, not necessarily just pertaining to noise. However, the establishment does not have any noise violations on its investigative history.
So explain to us, you said they do not have any noise violations in its investigative history. What does that mean?
That means there was no ABCA investigator able to substantiate any noise complaints since the establishment received its liquor license on March 21st of 2025.
Okay. Can you go through can you just identify the exhibits, if any, in your report, please?
I sure can. Would you like me to go through the exhibit list, or would you like for me to show the exhibits?
Just identify the exhibits. So show us and identify the exhibits in the report, please.
Absolutely. This is a protest letter that was submitted. Sorry. One second. Yes, from the group of 5 or more. That is Exhibit 1. This is an email. Exhibit 2 is an email that was submitted from Jeffrey Green. This is a protest letter submitted by the licensee. Well, a letter in response to the protest submitted by the licensee.
What exhibit is that?
This is exhibit number 3.
Okay.
And please let me know if you'd like me to go slower.
You can, no, I just want you to identify the exhibit for the record, that's all.
Exhibit number 4 is the GIS map of any schools within 400 feet of the establishment. Exhibit 5 is the GIS. This is 5. The GIS map of ABC licensed establishments within 1,200 feet of the licensee. This is the establishment's current certificate of occupancy.
Which is exhibit what?
Exhibit 6.
Thank you.
This is an exterior photograph of the establishment.
Now I need you to identify the exhibits for the record when you describe them, please, okay?
Absolutely. Exhibit 7 is an exterior photograph of the establishment, which includes the residences on the 3800 block of Georgia Avenue. Exhibit 8 is a rear photograph of the establishment to include where their summer garden is located. Exhibit number 9 is the front of the establishment, the front entrance to 3813 Georgia Avenue. This is the establishment stairwell, which is seen upon entry into the establishment, and this is Exhibit 10. Exhibit 11 is part of the first floor dining area of the establishment. Exhibit 12 shows the first floor bar area as well as dining area of the establishment. Exhibit 13 is the rear area of the first floor of the dining area of the establishment. Exhibit 14 is also part of the dining area of the establishment on the first floor. Exhibit 15 shows the enclosed summer garden area of the establishment located in the rear dining area. Exhibit 16 also shows the first floor dining area. Exhibit 17 are the restrooms offered to the establishment's guests. Exhibit 18 is a photograph of the establishment's kitchen. Exhibit 19 shows part of the establishment's second floor area in the front of the establishment, facing Georgia Avenue. This is a part of the second floor area in which entertainment and dining is offered. I believe this is to be used as a VIP area. Exhibit 21 is also of that second floor VIP area. Exhibit 22 is a photograph of the establishment's second floor area. And if you look to the rear, you can see where the band is typically set up. Exhibit 23 is a part of the establishment's second floor area. Again, Exhibit 24 is the same. Exhibit 25 is a photograph of the, I guess you would, I'm not sure what to call that machine where you pay for parking, but I'm sure we're all familiar with it, parking in DC. This is located on Georgia Avenue that allows for street parking for guests for the establishments or neighboring businesses. This is a photograph of the parking signs that are located on Georgia Avenue. I believe there are approximately 8 spaces on each side of the street that allows for public parking between 2 and 3.5 hours. And this is Exhibit 26. Sorry, this is, I believe it is Quincy Street. Yes, I believe this is Quincy Street. This is a picture of the parking where there's a no parking area close to residences within that area, as well as what is 2 to 3.5 hour parking allowed. That is Exhibit 27. No, this is Quincy Street as well, just to show some of the parking in the surrounding area, as well as a Dunkin' Donuts, which is across the street on Georgia Avenue, another business open to the public. sorry, exhibit number 29 is an apartment building located directly across the street on the 3800 block of Georgia Avenue, which also allows for street parking in its front. This is a photograph of street parking signs located on the 3800 block of Georgia Avenue in the same area in which I showed in Exhibit 30. This is the same, showing the street signs for 2 to 3.5 hour parking. And this is Exhibit 31. Also, the 3800 block of Georgia Avenue exhibiting some of the parking as well as vehicular traffic in that area. This was taken during day hours. And this is Exhibit 32. This is a photograph of Randolph Street, which also allows street parking on a street of residences also located in a residential zone. And this is Exhibit 33. Exhibit 34 shows the alleyway in which the establishment shares with residences that are located in a residential zone. This is also a photograph of the residences within the residential zone in the area. This is in the establishment's rear. Exhibit 36, I do believe this is 8th Street Northwest, which allows for 2-hour parking between 7 a.m. and 8:30 p.m. And that is Exhibit 36. Exhibit 37 is a copy of the sound test report that was submitted to the protestants, licensees, as well as the Chief of Enforcement. Exhibit 38 is a copy of the calls for service that was submitted to me from the Office of Unified Communications.
I'm sorry, you said exhibit which one? Okay, all right.
38, would you like me to return?
Yeah, let me just want to make sure.
And that is the calls for service to the 3813 Georgia Avenue Northwest.
That's fine. There's one question I'd forgotten to ask you earlier. I think Mr. Kadir talked about it, and I think there's some mention in your report about some light that that shines in the alley. Can you talk about that if you're aware?
Yes, I was able to view the light. There's a small security light that is located in the rear of the establishment that flashes between blue and red lights. I asked the licensee, Mr. Swaby, about this light, and he advised me that he did not install it. It was installed prior to him moving in the establishment, and he was unsure who would be responsible for it.
All right, fine. Mr. Kadir, this is not an opportunity for you to ask questions, so you'll have an opportunity to question her when you have an opportunity. Okay, sir? All right. Any questions by any board members of Ms. Nelson? Go ahead, Mr. Meadows.
Good afternoon, Ms. Nelson.
Good
Excuse
afternoon.
me. You mentioned in your testimony that there have been 20 complaints since March 2025. Could you break those down on categorize them? How many basically were for noise?
So unfortunately, Mr. Meadows, I do not have that information regarding how many specifically were for noise or for other things. I can tell you from my own experience with monitoring the establishment and conducting this investigation that there was a mix of complaints for noise, as well as offering cover charge without an endorsement.
Okay, thank you. And you highlight the times that you went out. You were in the establishment while the other investigator was at another property. About how was that on Georgia Avenue? That which street was that on where the other investigator was?
That was 8th Street Northwest.
I'm sorry.
That was 8, like the number, 8th Street
Uh-huh.
Northwest.
Okay, and so basically a block away.
That resident shared the alleyway with the licensee,
Okay.
so directly behind.
Okay, directly behind, and I believe that was written on a Wednesday. Is that correct?
Yes, I do believe so as well. Yes.
And so, did you go and for any noise investigation about the noise? Were you there on any Thursday, Friday, or Saturday or Sunday? Because
Yes.
you did say you went out many times. I think it was 13, but and
Yes, I
on
did.
they were?
Yes, we had, myself and other investigators have visited the establishments during those times.
Okay, all right. That's what is helpful to know. Thank you. Thank you,
Thank
Mr.
you.
Chairman.
All right, any other questions by any of the board members? Mr. Jackson, do you have any question of Ms. Nelson?
Yes, I do. Good afternoon, Investigator Nelson.
Good afternoon, Mr. Jackson.
And thank you for a very thorough report. Ms. Nelson, first of all, do you know if there's any other establishment in the area that provides entertainment as well?
Yes. 1 second. I have that in my report. Yes, there is.
And how far from the applicant establishment is that establishment?
So
If
of
you
the
know the
8,
distance.
I don't know the distance, however, I do have the address.
Okay.
Would
Now,
you like for me to?
yes, please.
Okay, Mr. Jackson. Please continue, I'm sorry.
No, you're providing.
No, I
the
was
address,
asking
Ms.
you, you can
Nelson.
present the address.
Okay. Of the 8 ABC licensed ABC licensed establishments within 1,200 feet, Snappy's located at 3917 Georgia Avenue has an entertainment endorsement. Pantry Thai Bistro and Grocery located at 3617 Georgia Avenue Northwest has entertainment. Afro Lounge located at 3630 Georgia Avenue, and the Looking Glass at Temperance Hall located at 3634 Georgia Avenue Northwest all have entertainment endorsements.
From your recollection, do you recall if you received any complaints for noise from any of those establishments?
I cannot speak to that at the moment. I'm sorry, sir.
Okay. Also, you had made mention that there were a number of complaints that you pulled from the command center.
I'm sorry?
You mentioned that there was about 23 or 24 complaints that was
yes.
made upon the establishment.
Okay.
Now, were any of those complaints substantiated?
Per the investigative history, I can't say whether the only thing on their investigative history was substantiated by a complaint or not.
Okay, from your experience, just because a complaint is made doesn't mean that it's a substantiated complaint, correct?
Yes.
You mentioned that in the alleyway that there were some lights, blue and red, or some sort of security lights in the alleyway.
Yes.
Were you aware that those lights are controlled or was placed there by the Metropolitan Police Department?
No, sir.
Okay. Also, when you went in the alley, did you notice any trash that was outside of the trash dumpsters or trash in front of the establishments?
No, I did not make note of that.
Did you have a chance to speak with the applicant concerning video that they have of residents illegally dumping trash around their dumpster?
Yes, he did make me aware. However, no, he did not show me any video.
Okay, could you explain exactly what he made you aware of?
That there have been times where he has found trash inside of his dumpster from neighbors dumping inside of his trash.
You mentioned also that there was a line outside of the establishments during your visits?
No, I did not make mention of that.
Okay.
That was,
Did you see any lines outside of your establishment, outside of the establishment during your visits?
no, not during the times that I visited. I did not.
Okay. Did you see any issue with parking when you visited the establishment?
The 3800 block of Georgia Avenue and the surrounding area, parking is limited. So I can't say whether parking is limited because of city law or if it's due to patrons visiting the establishment. I did witness patrons commuting to the establishment either by walking or using rideshare, in which they will double park on Georgia Avenue, but I can't say the people parked on the street were necessarily going to the establishment.
Okay, so it's fair to say that the parking issue or the limited parking is not an issue that the establishment created, correct?
I can't speak to that for sure.
Okay. Also, during your visit and when you was conducting the sound test, did y'all come into some sort of agreement as to what the level should be maintained, that the noise could not be heard emanating from the establishment to disturb the residents?
No, we did not.
Was a level discussed as to where they would keep that sound level?
No, we did not.
Who was present during the sound testing? Were they able to confirm that the noise couldn't be heard if this noise was kept at a particular level?
Are you asking me who was inside of the residence or who from
Yes, inside of the residence.
Okay, that would be lead investigator Vanessa Playtest was inside of the residence.
Okay, and I noticed that in your report that when they did play the music at a certain level, it was not able to be heard inside of the residence, correct?
Yes, that was investigator Playtest's findings.
No further questions, Mr. Chairman.
Mr. Kadir, you have an opportunity to ask questions of Investigator Nelson based on her report.
Yes, thank you. Good afternoon again, Ms. Nelson. Thanks for the report. Thanks for coming to join us today. I have a few questions, just sort of in order of things that you said during your testimony and also in response to Mr. Jackson's questions. The first I wanted to ask, could you define maybe succinctly for us what constitutes entertainment, what the establishment is licensed to do?
If you give me 1 second, I can speak to you directly from the regulation to give you the definition of entertainment. Okay. So per ABCA regulations, it defines entertainment as with the following statement. It states entertainment means live music or any other live performance by an actual person, including live bands, karaoke, comedy shows, poetry readings, disc jockeys, and trivia nights, during which microphones are used. The term entertainment shall not include the operation of a jukebox, television, a radio, or other pre-recorded music.
Okay, thank you. And you mentioned that that the license and that the applicant said that they have entertainment on a regular basis. Is there an actual definition of the term regular basis, or is that just the term you've used?
I can't speak to what the intended meeting is, but I do know the licensee is approved to offer entertainment for his ABC license.
Yeah. You mentioned that they expressed that they would have entertainment on weekends, like Thursday through Saturday. Would having karaoke on a Tuesday night be a regular basis?
I'm sorry, Mr. Kadir, I'm not quite sure how to.
Would that be considered within a regular basis to have entertainment, to have karaoke on a Tuesday night?
No, I don't believe so, but I
Okay.
can't, that would be given my opinion, which I can't necessarily do.
Okay. Would it be considered a regular basis to have a stand-up comedy show that's audible in the alley behind the establishment on a Tuesday night or a Wednesday night? Is that a regular basis of entertainment, if that's something that regularly occurs there?
Again, Mr. Kadir, I can't speak to what would be considered regular basis.
Okay, thank you. Moving on to when you mentioned that they had ticket sales that you were able to find in the establishment, and there was areas that people were not able to access without having paid for a ticket. A few questions related to that. Was the establishment fined or penalized in any way for going outside of his license on this occasion?
No, sir, because the ticket sales did not prevent entry from patrons using the establishment in its intended nature as a restaurant.
So when would you need a license to have ticket sales and a cover charge? Would that would only be to cover the entire establishment then?
To prevent entry, to pay
Yes.
to enter the establishment.
Yes. Okay, thank you. I'm gonna hold on to that one. And then so the reason they weren't penalized is that it wasn't preventing access to the entire establishment, but just to a part of the establishment.
Because that would not be considered cover charge. That is
Okay.
why they.
Okay, that's like a VIP experience or something like that.
Yes.
Okay. Were you able to ascertain how many times they have, or how often they have charged for this kind of thing? Or was it just on the visit that you saw and you know that they were doing it on that time when an investigator visited?
No, I'm sorry, could you repeat that question
Yeah,
for me
were
one
you
more
able
time?
to ascertain how many times or how often they have hosted events where people need to pay to access a certain part of the establishment? Or was it, or you just saw that it happened on the time when you or another ABCA investigator visited?
Um, if you're asking, do I have the number of time that they offered ticket sales? No, sir, I do not.
Okay. Do you have any idea how much money they've made from the ticket sales? Is there like, is that information that ABCA receives or that anyone in the DC government receives?
I'm sorry, Mr. Kadir, I went out just a bit. Would you mind repeating
Sure.
that question for me?
Do you have any idea how much money, how much revenue they've received from these kinds of ticket sales? Is that information that ABCA would receive or that anyone in the DC government would receive outside of the taxman?
I can't say if any establishment has received that information, no, sir.
Okay, thank you. You mentioned when you were in the establishment while Investigator Pleites was in Mr. Green's home during the test, that you spoke to the owner of the establishment, Mr. Swaby, about despite the results of the test, trying to maintain a level of sound that was appropriate, or you said, I think, make them aware of complaints and the effects of their noise, was something like that you said. Is that, was there any obligation put on the owners or on the establishment to abide by what you advised him to do?
As far as the sound test or when we receive noise complaints?
Not neither. When you said that after the noise complaint, you said you made the owners aware of the complaints from neighbors and the sounds that was coming through, including to homes that were not tested during the sound test. Was there anything during that conversation, as far as you can recall, having some sort of obligation that they should actually that they should respect what you mentioned?
If you're asking if we obligated them to lower the music,
Yeah.
no. We advise and we ask that they lower the volume of music to work with the community.
Okay, thank you. One second. Could you tell me either specifically for I know there's 20 calls that were made to ABCA. Maybe it wouldn't be possible to give this on a basis for every single one of those, but what is the average response time for ABCA when a call is made? If someone makes a noise complaint at midnight on a Saturday night, how long does it usually take for an investigator to come by? And if you are you able to specify that for any of the complaints that were made against the applicant?
That is information that I do not have, unfortunately, the average response time.
In your experience, then, not the average agency-wide, but in your experience, what would be the average response time, or in your career?
The best that I can tell you, because we don't have average response times, we're not necessarily
Yeah.
MPD.
I understand. Yeah.
We do respond as quickly as we can to any and all complaints.
Okay, thank you. Is there like a minimum required response time? Like we have to be there within 30 minutes, within 45 minutes?
No, there is not.
Okay, thank you. So is it possible that in between when someone has made a noise complaint and when ABCA arrives, that the noise has diminished?
Are you asking me my opinion on if that's possible?
Yeah.
Or I suppose it could be possible.
Yeah. Is it possible that if someone both calls the establishment to complain about the noise and complains to ABCA, the establishment knows that someone from ABCA is coming within, say, 45 minutes, an hour, to check on the noise? That's a possibility?
Yes, it is possible for someone to
Yeah.
call the establishment and call us at the same time to complain about noise.
Okay, thank you. I don't see the list of complaints. I'm sorry if I'm just missing something in the evidence. Are you able to tell us how many of the complaints were made before the sound test on September 24th?
No, I cannot speak to that, unfortunately.
Okay. And when you were visiting, I understand, again, if you weren't able to observe this so thoroughly, did you notice any evidence of above and beyond visible sound insulation in the establishment, in the inside of the building? Did you notice any typical sound insulation that you would find of a bar, a restaurant that is playing music at the volume that they do?
I believe the establishment did have a typical setup for a typical bar. That's which.
What does that
Are
mean?
you asking if they have any soundproofing currently in the establishment?
That's part of my question, yes.
Okay, not that I am aware of, no.
Okay. You said it was typical setup for a bar or a restaurant. What would be a typical setup of soundproofing for a bar or a restaurant?
Exactly what they have,
Which is?
windows, closed doors that
Okay.
allow patrons to enter and exit. It is covered with brick, as most
Yep.
places in the district are.
Thank you. What would be typical sound insulation for a place that was not licensed as a restaurant, but as a, say, nightclub?
I can't speak to that. I'm sorry.
Okay. And then while the sound test was going on, and the band was upstairs playing, were you ever in the summer garden listening to the sound from the summer garden?
Yes, I did listen to noise from the summer
Okay.
garden.
And noise comes from the upstairs to the summer garden? You could hear, as in you
Yes,
could
it
hear
does.
noise from the upstairs into the summer garden?
Yes.
Yes. Did you ever stand outside of the summer garden listening to the music? Like directly outside? Okay. Thank you. And when you visited, did the establishment have their door? It was a nice September day. Did they have the door to the summer garden open?
The door to the summer garden, or are
Yeah.
you speaking of the front door?
The back door to the summer garden.
No, not on my visits that
Okay.
I've witnessed.
When you were standing outside in the summer garden and you could hear the music from upstairs, the door to the actual physical building was closed.
This was during the sound test,
Yeah.
or
Yeah, during the sound test.
I don't recall if the door was opened or closed.
Okay. But you could hear noise. You could hear the sound test from the summer garden.
Yes.
Okay, thank you. Excuse me, just a couple more. Could you explain, please, what are the quiet hours for the zone that directly faces Georgia Avenue, NMU-7B-GA? And then what would be the quiet hours for the other three sides of our block that are entirely residential?
So it is my understanding, Mr. Kadir, that there are no quiet hours. You are not able to hear noise at an inaudible level at any point of time during the day or nights.
Can you say that again, please? You're not able to.
It is my understanding that there are no quiet hours.
And then you said something else. You're not able to
Hear noise emanating from the establishment at any point of the day, except for places that are listed as exceptions.
So I should not be able to hear noise emanating from the establishment at any point of the day.
And in places that are not included in the exceptions, if you are referring to 25-725 of DC Official Code.
And is this building an exception?
It is located in a neighborhood mixed-use zone, as well as the 3800 block of Georgia Avenue Northwest.
Okay, but the sound, I guess, affects people who don't live in that mixed-use zone, right? So how does that affect then the people who don't live in the mixed-use zone?
That is not something that I can speak to as well. I do know, as far as complaints go, I don't necessarily know what zone that the complainants have off the top of my head. So I can't say how it affects them unless I speak with them directly.
Okay, should I tell you, or is there no reason to do that?
Is there a question that you have for me regarding my protest report?
Mostly residential. I'll get to my last question. I have my last question. You mentioned, and Mr. Jackson also asked you, whether an agreement was made about the noise level or discussed with both the applicant and the protestant during the sound tests, correct?
Yes.
And the answer was negative. I guess I'm wondering why that was, because it was mentioned in the report that there was no agreement made. You mentioned it during your own testimony, and then Mr. Jackson has asked you about it. I don't recall having been asked about coming to should on September 24th, should we come to an agreement? So was there supposed to be some sort of coming together? Let's make an agreement. Can we talk about the sound level?
Yes, I believe that was the purpose of the sound test, was to define an agreeable level in which the neighboring residents and the licensees could play without disturbing the residences. Are you asking why, or?
Sure, why?
During the sound test, we were unable to come to an agreement, because at the typical volume in which the establishment told me that they were playing, lead investigator playtest was unable to hear noise inside the neighboring residence. when the band played at its loudest volume, which they advised me was unsafe to their instruments. That's when she was able to hear music inside of the residence. I was also advised that each form of entertainment would play at a different volume, so the noise would be heard differently. Additionally, each performer would have their own sound engineer in which they would play at different volumes. So we were unable to have a conclusive sound level to play at.
So sorry for one follow-up question. So the band who was there said that this would be harmful for their instruments or their amplification, but it's possible that another band's DJ could come in and set up some speakers that could get vastly louder than what the band had. It was just them. It was their level.
Yes, they just advised me that their level, it was harmful for them to play at that level.
Okay, thank you. No further questions.
Thank you, Mr. Kadir.
Thank you.
All right. Thank you. Thank you, Ms. Nelson, for your testimony today.
I have a follow-up question.
Mr. Jackson,
The testimony of Mr. Kadir.
Mr. Jackson, this is my
Okay, sir.
witness, and I'm not going to allow any follow-up questions, sir, because we need to move this matter along. If you need to, hopefully you can call a witness to answer whatever question that you have, sir. Okay?
Okay. All right.
Thank you, Ms. Nelson. Thank you for your testimony.
Thank you.
Have a great day. Thank you. All right, Mr. Jackson, do you have a witness you wish to call?
Yes, I'd like to call Ms. Swaby. Melissa
How many
Swaby.
witnesses do you have, Mr. Jackson?
2.
Okay. All right, Ms. Swaby, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Your witness.
Yes, good afternoon, Ms. Swaby.
Good afternoon.
Ms. Swaby, could you spell your first and last name, please, for record?
First name is Melissa, Melissa. Last name is Swaby, Swaby. Pronounced Swaby.
And what is your affiliation with the establishment?
I am the co-owner of Cito Oasis.
And how long has the establishment been open?
The establishment opened the end of March of 25.
Do you know your approved hours of entertainment?
Yes. Our approved hours are the opening hours as Monday through Thursday, 4 p.m. to 12 a.m. And Friday and Saturday, we are actually approved from 1 p.m. to 2 a.m. and Sunday, 12 p.m. to 12 a.m.
During those hours of operation for your entertainment, have you been in compliance and operating during those hours?
Yes.
Have you had the opportunity to speak with any of the complainants or protestants? Or have they ever visited your establishment?
They have not visited our establishment. We've only spoken to them through controlled meetings, through ABRA or meetings that we've had prior to this to try to come to an agreement.
Do you recall the sound testing that was conducted at your establishment?
Yes, I do recall.
And are you aware that mediation is for coming to an agreement, not the investigators?
Yes, I'm aware.
Have you had an opportunity to meet with the protestant to discuss coming to some sort of agreement on the sound level?
No, not outside of the scheduled meetings we've had through these type of agreements. No.
Was the applicant and the protestant ever informed or inquired that you were willing to make some sort of agreement or come to some sort of agreement?
Yes, we've made it very clear that we'd be willing to come to some agreement, but there was some pushback. So it seemed like there was not an agreement going to be made anytime soon. So that's why we're here at this point.
Okay, and it was mentioned that there was some video of some residents illegally dumping trash around your establishment and then calling to complain about the illegal trash?
Yes, correct. I've caught residents, passerbyers, dumping trash on several occasions. And we know that it's not our trash because when we open up the trash can, it has other restaurants like Popeyes or local Wendy's, but not this Wendy's because this Wendy's has been shut down for a while, but other type of Chipotle. Also on the outside and behind our trash cans, there's trash, which we did not put. There's beds, there's tires, miscellaneous trash on several occasions. Oftentimes when waste management comes to pick up the trash, they're not very careful with the locks. When they open up the trash can, they fly up the lids and the locks get disattached or the locks actually break. So it's left our locks open to anyone. So people have noticed that on several occasions and they do dump.
Do you have anything in place that you have monitored your residents or your patrons coming out of the establishment and illegally dumping trash or making noise and disturbing the residents?
Um, as far as we have cameras in multiple areas within the establishment and at the rear and the front of the establishment. So we can see when people are doing things illegally. We've come out several times and we noticed that the items that are outside are not items that we sell. Um, One of those examples would be a canned beer. We don't sell canned beer. We don't sell small bottles of alcohol. Everything that's in the restaurant is consumed within the restaurant itself. We do not allow anything outside of the restaurant. And our patrons are very aware of that. We stop them if they proceed towards the door, even with a plastic cup. We make sure that they actually finish what they're drinking before they exit the building.
Have you ever had any interaction with any of the protestants in relation
No.
to your establishments or their concerns?
No, no personal interactions, no face-to-face interactions, only in a controlled environment as such, like this, where we're having today.
Could you tell us your intentions of having the cover charge and the dancing?
Yes, so the intentions of the cover charge and dancing, like you had alluded to before, was to provide an opportunity for additional funding for ourselves in a form of birthday parties, bachelor parties, retirement, networking events, fundraising to provide supplement for the restaurant because things are rather slow. And as you're aware, many of the restaurants in the district are closing, and we're not free of that problem. So we're trying to maintain to keep our doors open as much as we can.
And how often do you think that you'll be having this type of entertainment?
About 3 times a week.
Are you willing to come to some sort of agreement with the protestants so to have a happy medium and be a good neighbor?
Of course, we're always willing to, meet the residents or neighbors, 50-50, half of the way. But this is, it has to be a give and take. We can't be constantly put in a predicament where we're not being recognized for what we're doing in the good way, but also we want to make sure that we maintain a healthy environment for people to come to enjoy the restaurant, to eat a dinner, have a drink, or just to talk or to meet up with friends. We're not there to cause a problem or anything like that for the neighborhood. We just want to be able to, have this restaurant so people can enjoy our cultural foods and also bring others that can share in on this.
Do you feel that you have any support from the neighbors as far as patronizing your establishment?
None at all.
No further questions, Mr. Chairman.
Mr. Kadir.
Yeah, thank you. Thank you. Good afternoon, Ms. Swaby. Thank you for joining us. Wanted to ask first regarding the trash that Mr. Jackson has mentioned, and you said you have video of residents dumping the trash. Is that correct?
That's correct.
Yeah. Have you identified any of the protestants, any of the signatories of the original protest as those who have dumped trash, as Mr. Jackson mentioned?
No, because I never said that those people were
Okay.
the ones that were dumping. I said random individuals,
I understand.
people that passerbys. There are several people that walk through the alley that possibly don't live in the neighborhood that are just passing through to access other streets within the neighborhood. There are also, probably people that are just hanging out in the neighborhood that don't actually live there. So no, I have not witnessed um, any of the people that are on this protest as one of the dumpers, and I did not say that they were.
Understood. Thank you. Going to Mr. Jackson, asking about the reason for the cover charges. Mr. Jackson said, I'm not asking you to verify his words, but just to note, he said in his very first statement that, and he's representing you, that the purpose of the cover charges was to raise funds. He mentioned for people in, I suppose, Jamaica, for people in another country, and so that these cover charges would go to fundraisers. But you've just mentioned, and Mr. Jackson also mentioned in his opening statement, that the funds would also go to revenue to support your business, which, as you just said, the business is slow. So are the cover charges for fundraisers, or are they to support your business, or is the business the fundraiser? Or is it both?
I think it was very clear on what was said. One of the options isn't a fundraiser. And just to piggyback off of what you said, we were raising funds for Hurricane Melissa as well. So, the aspect of this is to also do have activities that can support the business as well as support the community within itself.
Yeah, thank you. I'm just trying to understand the nature of the cover charges and the relationship between the revenue and the fundraiser. So there
I'm sorry. Let me make this clear.
Sure.
I think we both understand what a fundraiser is. So a fundraiser is usually for a cause.
Thank you.
So the fundraiser is for a cause. And the other cover charges are for functions that could possibly happen within the restaurant that are not solely for that reason.
Okay,
So I want to make sure we're clear on that.
Yes, thank you. That was my next question. So some cover charges will sometimes be for specific fundraisers, and some cover charges will go directly as revenue to the restaurant. They're not meant as charity events or anything like that. That's
a possibility, correct?
What's the other possibility?
The two that we're talking about. There's one or two.
Okay,
There's either it's very clear.
Yeah, and you mentioned that you might have cover charges 2 to 3 times per week. How often? So is it per week or per month or per year? Do you expect that those would be fundraisers?
You're asking for me to foresee the future. I can't foresee the future. If a cause comes up and it's something that we want to support, we will support it.
How many times have you done a fundraiser since you've opened last March?
The fundraiser that we did was for Hurricane Melissa, and actually we did not have a good turnout with that.
Okay, understood. And that was just one fundraiser.
That's correct.
Okay, thank you.
So, and just if I said it was not a good turnout, that means there were no funds collected for that.
I understand. Thank you. I'm
And
sorry.
it didn't come directly to Cito Oasis.
Yeah, I understand.
Okay.
Thank you. I'm sorry about the turnout there. You mentioned that you are attempting to be a good neighbor. How else have you been a good neighbor since you've opened last March?
Okay, so again, we talked about we had a backpack drive for back to school. We did that as well, and we did feed the community for Thanksgiving. We did
Yeah, I
both
saw
of
that.
those items. Okay.
Keep going. Sorry to interrupt.
That's what we've done so far besides Hurricane Melissa.
Okay, thank you. Do you train your staff on customer service?
All of the staff have been trained on customer service.
Yeah.
I don't control people, but they have been trained.
Yeah. Do you train them on responses to noise complaints from neighbors, what to do? Or advise them, tell them what to do if someone makes a noise complaint, either in person or over the phone?
If there's a noise complaint, they're supposed to get a management on staff.
Okay. So management are trained on how to respond to a noise complaint specifically?
It's common sense how to respond to a noise complaint.
What do you mean by common sense? What would be common sense to respond to a noise complaint?
To be polite and to hear the person out and to say, okay, thank you, we'll adjust it and we'll do what we have to do to make sure we're okay.
So being polite would not include hanging up the phone on neighbor who's made a noise complaint? Would that be included in being polite, or yes or no?
I have not witnessed it because I'm not there most of the times at night.
Okay.
But if the person is being hung up on, I'm sure there was a reason or something happened to initiate that or to start that. So I can't speak on that. I'm sorry.
Yeah. If a neighbor called and mentioned that it was a school night and that they were trying to fall asleep, would that be reasonable, or would that be a reason to hang up the phone on someone?
I think it's reasonable.
Okay, thank
I
you.
think it's reasonable complaint.
And if you
It's
found that the
reasonable.
manager was hanging up the phone in that manner on people who were making reasonable complaints, would they be penalized or punished in any way?
Penalized or punished, we're all adults. That person could be pulled aside to discuss we all have to be on the same page. So that person should be pulled aside and discuss on how to handle things in a better manner. That's what I would do if I was on site.
Okay, thank you. I just have one more question or sort of line of questioning. Um, the Is it your policy to leave your front doors open on especially Friday and Saturday nights? Is that typically what you do on a Friday and Saturday night?
Okay, so I'm sure you're fully aware how the building is, how it's structured. The outer door is left open, but the inner door is closed. We leave the outer door open so that people know that we're actually open and we're open for service.
Um, okay, and what about the back door to the summer garden? So I asked Miss Nelson, and she wasn't sure what was the typical practice on a, say, Friday or Saturday night when there's an event going on. But what is the typical practice on, especially a Friday or Saturday night? The door between the physical building and the summer garden, is that door typically open or closed?
The door is typically closed. As far as safety reasons, there's a back door to the summer garden which
Yeah,
stays closed at all times.
yeah,
Because that door opens into the alley. If it stays open, a passerby could easily come
yeah,
in and cause damage or harm to us and steal product.
yeah,
Or it could also be an issue where a car or truck could probably hit it
yeah,
and we will have no back door.
yeah. Understood.
And plus, that back door is the trash cans are kind
Yeah,
of caddy in front of that, so that's also not a safe
yeah, and
door
the
to have
smell.
open at all times. I mean, it's common sense with that as well. We don't open the back door.
Yeah,
That's
thank
a
you.
safety issue for us and our customers.
Yeah, thank you. Have you ever noticed noise coming out the front door when you have that front door open but the interior door closed?
No, I haven't noticed any noise. But
Sound
if
mu-
you're passing by, you can probably see people moving about and talking through the glass.
Mm. Would seeing people moving around and talking through the glass inside a restaurant be a good indicator that a restaurant is open?
Yes, that would be a good indicator that the restaurant's open.
Okay, thank you. Going back to talking about the
But
customers. Yeah,
also on that too, our windows were tinted and we removed the tint so that
yeah,
customers could see us.
yeah. I noticed that.
Um,
Yeah.
okay.
Um, Going back to talking about customer service, so say you mentioned that there's managers on site. Who are the managers? You don't have to name names, but how many are there? What are their shifts and so forth? How are they chosen?
I don't understand how that question is relevant.
I guess
An
I guess
owner
to
is
put it,
always on site,
yeah, to put it
and there's
to put it
always a manager, that shift lead,
yeah.
always on site.
Are you or Mr. Swaby always on site in one way or another?
It's a requirement for either one of us to be on site.
Okay,
And
so
we don't have to be there at the same time, but
yeah.
one manager has to be on site at all times.
I asked specifically about you and Mr. Swaby. So you said, but you did say one of you is on site at all times. So one owner is on site at all times, in fact?
That's correct.
Okay, that's great. Working in your business. Thank you. I think that's all I've got. Thank you.
Thank you. Any questions by the board members? All right. Okay. Thank you, Ms. Swaby, for your testimony. Mr. Jackson, do you have another witness you wish to call?
You're welcome. Thank you.
You're welcome.
No, sir.
You have no. So you rest?
Yes, arrest.
Mr. Kadir, how many witnesses do you have, sir?
I have two. And myself. I'm not. I count my. Do I count myself as a witness?
If you're going to testify,
Yes, I am.
because if you're going to testify, then I'm going to swear you in, and then you'll be subject to cross-examination. So are you saying 2 plus yourself, or are you including you're the 2?
Myself and 2 others. Yep.
The 3. All right.
Yep.
We're gonna finish the hearing today, so we're gonna take a 10-minute break. It's 3:39, well, 11. So we're off the record until 3:50. Okay?
All right. Thank
So
you.
we're off the record until 3:50. All right. Thanks. Everyone can. All right. We're back in the record. Mr. Oriana, can you allow Ms. Swaby to access? I think she said she got knocked off, so could you allow her back in, please?
I think one of my witnesses was also disconnected, Mr. Leland. He might have been, you might see that he's trying to rejoin as well.
He's already on.
Okay.
Dr. Leland, he's
Yeah,
there.
thank you. Thank you.
I'm here. Thank you. Yep. I'm back.
All right. Okay,
I'm
let's
back.
see.
Thank you as well.
All right, fine, thanks. Who's your first witness, sir?
Myself?
Mr. Kadir, you're the first witness?
Yes.
Can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Go ahead, sir.
Thank you. Well, I'll start over. I'll spare you some of what I've already read. But good afternoon again. Greetings to the chairman and to the other members of the board, and to everyone attending. Just to repeat, my name is Adam Kadir. I'm the primary protester on the petition against their application for modification. I live at 3811 George Avenue Northwest. I share a wall of my apartment with the upper story of the applicant's business. And I'm a teacher at a public school here in DC, and I'm also attending graduate school at the same time. Just to recap our protest to the proposed modifications, it's based on 4 points. Number 1 is noise emanating from the establishment. Number 2 is crowd control in public areas around the establishment. Number 3 are unlicensed activities in the establishment. And number 4 is respect for quiet hours in the neighborhood. And so I've already mentioned some references to the DC code regarding real property values, the effects of the establishment on peace, order, and quiet. And I've mentioned the nature of our neighborhood, as Ms. Nelson also mentioned during her testimony regarding the other ABCA licensed establishments nearby. And she mentioned the entertainment that they offer. So I want to go and talk some more about the noise and give some more detail about the noise that is coming from the establishment and my personal experience with it. I want to start by saying, since, as I did in the mediation hearing in November, I do thank and recognize the establishment CETA for, as far as we can tell, lowering the volume since the sound test. That's why I asked Investigator Nelson if the number of complaints before the sound test and after the sound test, because the volume has simply been less. The concerts from last summer that were audible from blocks away have stopped. As long as any Friday or Saturday night that I've been home, or even a Sunday. There are fewer occasions when the music that they play can be heard in nearby homes, besides those that directly border or are very nearby the establishment. But I want to emphasize that the music has by no means stopped, and my neighbors and I have still been diligent about notifying ABCA whenever the music exceeds these limits or their licensed hours. I want to emphasize that the sound levels that were reached and that have been changed since the noise test are the minimum legal levels that have been met, and that is certainly recognized and acknowledged by us. That there's been a better attempt, although I think, in my opinion, still not perfect, attempt to meet those legal levels that were established during the test, to check if they were audible in a home in a residential zoning. But our protest to this modification rests on the overall effect of the noise on the neighborhood, not just on areas that may be residentially zoned or mixed use zoned that border the establishment or are across the street or across the alley. CETA's representatives have said in mediation hearings mediation meetings that they installed noise mitigation measures after they took over the space. While I'm not,
Mr. Kadir,
yeah,
you cannot talk about what happened, what was discussed at mediation, sir.
okay,
Okay?
sure,
All
I
right.
understand. Thank you. Sorry. I'll strike that. While I'm not clear what the measures were, what their measures, what their sound mitigation is, whatever noise mitigation they have is simply not enough. Almost any sound in the establishment is audible in my home. Whatever installation they do have, I ask the board to require them to improve this installation until their noise does not affect nearby homes at all. I need peace of mind in my home. We need peace of mind in our homes. Let me demonstrate to you what this looks like. Sometimes the music doesn't not even start until 9 or 10 p.m. on a weeknight, not to mention the weekend. Yes, their stated hours allow them to remain open until midnight on weeknights. But even when I've called the establishment after 10 p.m. on a weeknight to politely ask them to turn down their music, at this point, they say they will not, and they hang up the phone on me. As a teacher and as a graduate student, I have a lot of late nights and early mornings. I work on weekends to keep up, grading papers or doing readings on Saturday nights and Sunday afternoons, like I did this past weekend. How am I supposed to fall asleep on time to teach children in the morning when I have music bumping my walls until past 11 p.m. on a school night? Studies show that poor rest has a direct negative impact on teacher performance. When I'm not well rested, I cannot manage my classroom as well as when I'm well rested. I cannot take care of my students' social and emotional needs as well, and I cannot deliver lesson plans as well. I have tried repeatedly to ask the applicants to respect these hours on weeknights, and at this point, they immediately hang up the phone when they hear my voice. The applicants say they care about their community. I am literally their most direct neighbor, and I have expressed to their staff and multiple times over the phone the effect that their violation of quiet hours has on my home, and yet they hang up on me when I try to call. Let's talk about the summer garden behind the establishment in the alley between Georgia Avenue and 8th Street. The applicants have said that they don't play amplified music in the summer garden, and I think this was in the noise report. While I simply don't believe this, and I wonder whether they're talking on some sort of technicality, I have no evidence to the contrary, so I'm not going to affirm that. What I do know is that the music and voices are audible through the summer garden. Even just last Sunday, I could hear a daytime party going on from noon until almost 8 p.m. in the summer garden while I was trying to do work in my own home. On Tuesday nights, I hear stand-up comedy coming through the summer garden. On Thursday nights, I hear karaoke coming out of the summer garden. Sound leaks out of the building full stop. I will not accept any opinion to the contrary. I live next to it. I hear what I hear in my home. I can tell the difference between music coming through my walls and music coming through my back window from the summer garden. You can go and take a look at the summer garden. The summer garden is essentially blocks of concrete with a tin roof on top. It has no apparent sound insulation. You can see light coming out of holes at night in the summer garden. The sound will follow the light. All it takes is to stand in the alley when music is playing inside the house, and you can hear it in the summer garden, even if it's not being amplified into the summer garden. I want to emphasize as well that in discussing the summer garden, I am not just talking about my own situation, but that of everyone in our neighborhood. The nightly vibrations coming through my walls are one problem, but the summer garden affects dozens, if not hundreds, of people whose homes face the alley between Georgia Avenue and 8th Street. There are 3 large apartment buildings that face the alley. Anyone whose unit face looks this way would be subjected to this noise coming from the summer garden at all hours of the night. The summer garden affects all of us. If there were one outcome that the board were to consider from this hearing, it would be to require insulation of the summer garden. It is simply inappropriate that this structure can affect the lives of so many people with no functional sound insulation. When we do not live in a nightlife district, we should not be subjected to this, even if it is a mixed-use district. It is the single greatest nuisance that the applicants create to the largest number of our community. As I mentioned in my opening statement, adding a dance floor and a cover charge only means that the music will get louder, more frequent, and more intense. It means that more people will be lining up outside. The applicants are not requesting modifications to turn into a quiet restaurant that will bother no one. Which brings me to the crowd. Has the board received my exhibits that I submitted with my protest report last week?
Yes, sir. We have your PIP.
Okay, may I share those on the screen?
Mr. Oriana, can you give him an opportunity? Can you allow him to share his screen?
Thank you.
Access granted.
Thank you. Excuse me 1 second. Okay, everyone can see my screen?
Yes, sir.
So speaking of the crowd, I point the board to exhibits 1 through 3 in our submission. I'm going to play exhibit 1. And that was exhibit 1. I'm going to show 2 still images taken from across the street. This is exhibit 2, showing across the street taken from across the street, showing the establishment. And here's another angle. This is exhibit 3.
Is it 2 or 3?
This is number 3.
So what is number 2?
This is number 2, just slightly more zoomed in. I'm going to stop sharing my screen. What you saw in exhibits 1 through 3 were taken on videos and photos taken on the night of September 20th of last year. What you see is several dozen people, I believe coming from a Howard University football tailgate, I'm happy to be corrected, waiting to be let into the establishment. On that night, they blocked the entire sidewalk, reaching to the intersection with Randolph Street. They walked in the street itself. They loitered outside of my apartment, as you could see in the photos and video. They leaned on my fence, smoking cigarettes and marijuana, and I think, as I saw, left butts of those in my front yard. This was an event that did not have a paid cover, as far as we can tell from the event that they posted online. How is this establishment going to manage an event of a similar size that does have a paid cover? Will they have a rope line? Will they have anyone monitoring safety on the sidewalk? How will they check IDs and tickets in an efficient manner that does not disturb the neighborhood? What happens when they're at capacity? Will those waiting to get in just wait on the sidewalk, loitering outside of my home? What happens when those empty storefronts get filled? How will that affect them? I remind the board that this is not a nightlife district. This might be a site that you're accustomed to seeing in a rope line on 14th Street or 18th Street, but it is not a usual site on the 3800 block of Georgia Avenue. How will these proposed modifications fit into our community? When I brought up this concern during, let me strike this. Therefore, again, we asked the board to institute a requirement that the applicant come up with an approved crowd management strategy if their application is to be approved. The level of unruly crowds that we saw on September 20th cannot be repeated. It is not safe, it contributes to the noise, and it is not in keeping with the environment of the community. I would also mention that, as Investigator Nelson said during her testimony, that there was evidence that there was being a charge for a VIP area or a restricted area upstairs in the establishment, which means that this cover charge would be to the definition of a cover charge, as we learned from Investigator Nelson, is to deny access to the entire establishment, including that very front door, unless you pay the cover charge to get in, which means that necessarily there will be people waiting outside on this street, on the sidewalk at least, waiting to be let in. All I ask for is just 1 ounce of sympathy from the members of the board and the ownership of the applicants. I don't know where you all live, but think about living like this. You're sitting at home reading on a Sunday afternoon, and instead you get invited to a daytime DJ set against your will. You're working on your couch on a Tuesday night, grading papers, but instead you're watching a stand-up comedy show. You're cooking dinner with your partner on a Thursday, but instead you're front row at a karaoke performance. How would you like to live like this? How long do you think you could live like this? Do you think you could perform in your job like this? Do you think this is the right way to treat your neighbors or your constituents? What would you do in my situation? Would you stay? Would you move? This is my home. I should not have to move because of this unreasonable level of noise. I ask not just for myself, but for all of us who live in homes bordering the alley that can hear the applicant's establishment. I believe that I have a right to live in peace and quiet in my own home, which is mentioned in the DC Code, and it is incumbent upon the applicants to fix that. I wholeheartedly support a business trying to survive in DC, and I understand the difficulties that the ownership has mentioned in the current environment in DC. Having a successful business next door is vastly preferable to the space being permanently empty, like the spot just a few doors down at the corner of Georgia Avenue and Randolph Street. One of my favorite restaurants on the block just north of here closed down 2 months ago, even though it was frequently busy. Times are tough in DC, I know it. But the more open businesses we have on Georgia Avenue, the more eyes we have on the street, the safer we will all feel and be. With more businesses playing a positive role in our community, Petworth will also be a more desirable place to live in, and we will all benefit. Now, the applicants will respond to what I've just said, that if I don't support their business as a member of their community, then why haven't I been to their restaurant? And Mr. Jackson asked Ms. Swaby that same question. Have I been to the restaurant? I will say that I support lots of institutions in the city that I don't necessarily have to patronize. I want to live in a vibrant, diverse city where people can meet their wants and needs in various ways. There are lots of barbershops, yoga studios, and churches in the city that I don't go to, but whose continued existence I support. I find this argument entirely nonsensical. So I've proposed some solutions to the noise and that we want more insulation. We've proposed solutions to the crowd and that we want to hear from the applicants and have some enforceable measures as to how having an actual cover charge will actually function in our community. We have proposed solutions. We are here to make solutions, as we were during the mediation hearings. I look forward to hearing from the applicants and the respected members of the board as to how we can solve these issues that I've mentioned in a way that works best for everyone. I ask that you think about what it would actually be like in the golden rule to live in our situation next to a business like this. Thank you for your time and consideration, and I look forward to your comments and questions.
Mr. Jackson, any questions of Mr. Kadir?
Yes, Mr. Kadir, first of all, good afternoon.
Afternoon.
Mr. Kadir, first of all, are you aware that you moved into a mixed-use area?
Yes.
Okay, do you understand what qualifies as a mixed use?
Yes.
Okay, are you aware, first of all, have you been appointed by the community? You keep saying we, the community. Have the community appointed you to speak for them?
I believe I have standing as a member of the community to file this protest.
No, you have standing of 5 or more, not the community.
Yeah, I have standing of 5 or more as a member of this community to file this protest.
No, I'm asking you. You keep saying the community. Have you been appointed by the community to speak for your community?
Mr. Anderson, I don't want to answer this question.
Mr. Kadir.
Okay, secondly, okay, we're going to pass that. Okay, the pictures that you presented on September the 20th, is that the only time you saw a line outside?
That's the largest line I've seen outside. It's not the only time I've seen a line outside.
Okay, do you, are you familiar with Howard University?
Could you clarify the question, please?
Yes. Are you aware that Howard University is a few blocks away from the establishment?
It's more than a few blocks, but I'm aware that it's nearby.
Okay, so Howard University, when they have homecoming or events, they are able to have events at that location. That was a non-charged event, and that was during a pre-homecoming back to school event, which does not occur every weekend or every day.
Are you asking a question?
Is there a question?
Yes, I'm asking a question. That's why I asked.
Mr. Kadir, hold
a
on.
line out there on a regular basis?
I'm sorry, you were speaking at the same time. I wasn't sure if there was a question.
Do you see a line outside of the establishment on a regular basis, or was it that one incident?
I've already answered that question.
Mr. Kadir,
Could you repeat your answer, please?
I saw a line outside that establishment on that night. I have seen lines at other times.
Did you take videos of those other times?
No, I did not.
Were you present during the sound test?
Yes.
And what was explained to you that your location do not qualify for the residents in the other areas?
If you're saying that that the sound test could not be conducted in my home because it directly touches the establishment, yes, that was explained to me by Investigator Nelson.
Okay. And you said that you made contact with the establishment because you was trying to grade papers and you couldn't go to sleep.
I've called the establishment several times on weeknights, as well as on weekends, but on weeknights, because music was being played even past 10 p.m. When I was trying to go to sleep to go to school the next day.
So are you aware that their hours of entertainment allowed them to operate to 12 a.m.?
Yes, and I don't think it's appropriate that they be playing music that loudly in a residential area past 10 p.m.
Well, it's not residential, it's just mixed use.
Yeah, I see only residential surrounding them. So in my opinion, it's a residential area.
Okay.
They're
Also,
surrounded
you
on all sides by residential,
okay.
as I
So,
established in my opening statement.
okay. And the times that you contacted the establishment, that you hung up on them, what was your manner?
No. They hung up on me. They hung up on me. I did not hang up
Okay,
on
but
them.
what was your manner in your conversation?
I said, "Hi, good evening. I'm trying to go to sleep. I have to go to work in the morning. Sometimes I mention I'm a teacher, sometimes I don't. And then I ask if they can turn the noise off. And sometimes they have just directly hung up the phone on me. Sometimes they have said point blank that they're licensed to operate until midnight, so they're not going to change their noise level. And then sometimes they have verbally berated me, which was the last time that I called. And then I decided not to call again because I don't deserve to be verbally berated like that.
Okay,
They said actually
so
leave to never call again. So I'm following that advice.
okay, so you told them that you was a school teacher and you tried to go to sleep. So if you
Yep.
wasn't a school teacher, would it be allowable for them to
No.
continue operating?
No.
Okay, so I was just trying to figure out the importance of you identifying what your occupation was. No further questions, Mr. Chairman.
Thank you.
Any questions by the board members? Go ahead, Ms. Quinn.
Hi. One of the things that we often tell folks, and I know that Ms. Fletcher would have gone over this through the mediation process, is how important it is, or how much value there is to doing the best that everyone can to work towards an agreeable solution. And part of the reason for that is we are left as the board to try to figure out what's the best solution. And sometimes you're just not able to agree, and I get that. But here, I'm listening to you, and let's just take for example what you offered about the, I believe it was a summer garden, and you said you wanted to have, I think you said insulation around it. What does that even mean? Are we talking about an open outdoor space? How was that insulated? Like, what are you actually proposing? Because
Sure.
our job is now going to be to go back and look at this and figure out, are there solutions we can propose? And here we are just kind of grasping at
Yeah.
air to figure out what's what. So when you say you have solutions, we need to know specifics about what your ask is.
Sure.
I'm not saying that we can always get there, but that would be really helpful if you got
Sure.
some specific insight in terms of what you're looking for.
Sure. Thank you. Let me clarify then. I think on the summer garden, just to be clear as well, as you might have seen in Investigator Nelson's pictures, there is a roof on the garden. From as far as I can tell, the structure is concrete blocks and a tin roof. The tin roof is not even fully enclosed on the concrete blocks. As I mentioned, you can see light coming through. If I'm in the alley behind it at night, you can see light coming out. If you're walking in the alley behind it on a Friday or Saturday night, it is as loud as you are outside of it as you are inside of it. I have my window closed and my shutters closed right now, but I can see it directly out through my window here in my bedroom, which means that all the noise coming in the summer garden, all the people in there, can be just directly audible to someone standing a foot outside on the other side of the summer garden. And my bedroom window, and not to mention just me, but there are dozens of apartments just across the street, across the alley from me in the new Quinn building, and then on the other side, the north side of the alley, not to mention the single family homes, the row homes that do see the alley. That means that any music, any noise in the summer garden can be heard, because just anything that happens in the solution is to soundproof it. Sorry, the solution is to soundproof it. It's a concrete block with tin roof. And I don't see why, especially the residential people on the other side of the alley, and the apartment buildings on the south side of the alley, should be able to hear anything. I understand entirely that I'm in a mixed use zone, but I don't understand why it's appropriate that they can hear anything going on inside that summer garden. It has no soundproofing. It's not. I just want to not be able to hear what's going on in the establishment. I want to live in quiet in my own home. I want them to
wait, hold
soundproof
on.
and insulate. Yeah.
I don't need a whole nother testimony, but what I'm trying to get at is the summer garden, part of it is it's covered, but part of it is open air. There's some part that's
No,
open to
I mean, it's open
no,
air in the
it's
sense
not.
that it's not fully enclosed, in that the tin roof is not fully shut on. It's like loose on it.
Are there 4 walls?
They're fully closed, but you can hear
Fully
anything.
closed. Okay. Now I have a better understanding of what's going on. Are you aware of whether there is any kind of amplified sound on the summer garden?
They have said multiple times that there is not. I mean, regardless, and as Miss Nelson also mentioned in her, when I asked her, you can hear amplified music from inside the house in the summer garden. So if I could speak on that for a second too. So there's music in the house, in the establishment itself, that leaks into the summer garden. You know, the owners have said that they do not play music in the summer garden. I have no evidence to the contrary, but this music that is in the house goes through the summer garden. Okay. And that means that whatever's going on inside the building, inside the actual building, can be heard inside the summer garden and can be heard outside of the summer garden in the alley in all of our homes, right? In my home and in the residential row homes and apartment buildings on the other parts of the alley.
Okay. Thank you.
Thank you.
Any other questions by any of the board members? Mr. Kadir, a question I have to ask you. I know you talk about yourself and your neighbors, but your neighbors live in a residential zone. However, you live in a mixed use zone. And unfortunately, the way the noise regulations are written, because you live in a mixed use zone, I'm not sure if the regulations protect you. Because I hear you're saying that I can't go to sleep, I can't do this and I can't do that. But do you understand what it is to live in a mixed use zone? Do you understand that concept? Because I know you're talking about, I'm a teacher, I can't in the day. I mean, and even if there's regulations, I mean, during the day, there's really no, I know you talk about there's a quiet time. I'm not quite sure what you mean by there's a quiet time, but do you actually understand what it means to live in a mixed use zone, sir?
Yes.
So what does that mean?
It means that,
concern.
yeah, it means that I don't have standing to make a noise complaint about noise that can be heard in my home coming from the establishment.
But this hearing, I mean, and I'm not hearing, it's not apparent to me that in looking at the report that there has been any substantiated noise, that the agency has substantiated any noise complaints. Because I don't see.
That's because they didn't do the test in my home, because they told me we scheduled to do the test in my home. They showed up, realized I was next door, and so instead we had to do it from Mr. Green's home across the alley. I mean, I'm under oath. I can hear the noise all the time. I heard it last night until 11:50 p.m. I don't know what else to tell you. I hear it literally all the time, all day.
And I'm saying to you, because you live in a mixed use zone, the noise regulations that are currently in effect in the District of Columbia, you are one of the exceptions.
I realize that. The point of my testimony, Mr. Anderson, is that I think that there should still be consideration for the community. I'd also point out that we still have to hear from my other witnesses who live in fully residential zoned areas. But I want to point out that even if I live in a mixed use zone, I ask that the applicant themselves and the board consider the effect of the modifications on the neighborhood, because they simply have made a neighborhood not livable, both to people who live in a mixed use zone and to the people who live in the residential area. I ask it not out of regulation on my own part. They'll speak to themselves, but on my own part, I ask it not out of regulation or law or code, but I ask it simply out of just a standard of reasonableness, that this business not keep me up until 11:50 every night simply because they close 9 minutes later. I mean,
But
like,
I guess the question I keep on asking is, sir, I mean, are there substantiated noise violations in their record? I mean, are there, the report says there are 20 complaints, and I don't know what type of complaints they are, but it's not apparent to me that on their, at least on the history, are the neighbors complaining, and is it that the agency is able to substantiate the noise? Because the regulation states that noise cannot emanate into it for folks who live in the residential zone. That I think that if you live in a residential zone and you're here today stating about the noise that you're hearing in your apartment, then you could easily file a complaint. The agency would come substantiate that complaint, and there be violations. But I'm not quite sure if based on where your home is located, if there's much this agency can do to assist you. I don't know. And that's why I'm asking if you're aware specifically what it means to live in a mixed use
yes,
zone.
I'm aware of that. Yes.
Mr. Meadows. You're on mute, Mr. Meadows.
Yeah.
Hello, Mr. Kadir. Have you reached out to your advisory neighborhood commission and discussed this issue with them?
Yeah, we have discussed this. We've been in contact with him since, especially that Howard after party in September. I mean, he just has not been responding to us at a certain point, mentioning the noise, especially after we sent pictures and video of the Howard after party, how the noise was audible literally throughout the entire neighborhood for blocks. I'm not sure. And sorry, I was going to say that was that was on September 20th. The sound test was on September 24th. So they were still operating at a level. They hadn't been tested. They hadn't been told to keep at a certain volume. And then since then, it's just been no response from our ANC chair, Mr. Warburton, and I think Mr. Green as well will be able to speak more to that interaction as well.
And your council office, have you reached out to them?
I have not been in touch with our council member.
Okay, and we heard earlier that over 20 complaints were made concerning the establishment. Do you know how many complaints that you have reached out to ABCA on this establishment?
Yeah, I've made some complaints. I don't know how many off the top of my head. I also stopped making complaints after, as Mr. Anderson was mentioning, it was explained to me that living next door to them and in a mixed use zone, that my complaints essentially would not be heard or listened to, and that they couldn't conduct sound tests from my home. But I was making lots of complaints, not a lot, maybe 5 or so. I don't know the exact number, but I have made complaints, and I was making more until the regulations and the zoning were explained to me.
Sure, sure. I mean, I just think, overall, I understand what you face. I bought my house 22 years ago. My home is built in 1913. There are some things that I need to do to help. I live in a residential area. To my property, I deal with noise from my alley often. There are things that I need to do to alleviate that, but I do understand what you're speaking of. Thank you.
Thank you.
Any other questions by any of the board members? All right, Mr. Jackson, any questions of the witness based on the questions that were asked of the board?
No further questions.
And then, Mr. Kadir, any clarification that you need to provide, sir?
Just to reiterate, especially in line with Ms. Quinn's questions, that our goals are to have the establishment be required to provide sufficient soundproofing for both inside their establishment and outside so that noise does not emanate to residential areas. My own home, I understand the regulations surrounding my own home, but I believe that it should be required to control the noise and the crowds coming out into residential areas as well.
All right, do you have another witness you wish to
Yeah,
call?
call in Mr. Green.
Mr. Green, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you. Your witness, sir.
Mr. Green, could you describe, how long have you lived in your home?
So I've lived in my home for the last 16 years at 3814 8th Street. And I've seen multiple iterations of businesses at this particular location. It is in a decidedly residential neighborhood. Just because it has that one block has that zoning does not mean that this isn't a residential neighborhood. I'm gonna go back in the back machine when this applicant originally applied for their ABRA license, and I at that point was the lead protestant on that. And one of the things that I told this commission at that point in time that we would end up back here again because of this issue. And, the board at that point in time was like, yes, we understand that the prior businesses had the same issue, but, we have to give this operator an opportunity to prove themselves to us and to the community. In that time, the business, decidedly was like, we want to be a sit down restaurant. We want to be a restaurant. We don't plan on being, an entertainment, venue. We do not want to be a nightclub. Those were all things that they said under oath during that point in time. Fast forward, when they immediately opened, the first thing that they did was through an event that charged a cover charge that was outside of their license, and at that point continued to this date to throw events that in which they charge a cover charge, in which they operate as an event venue, not as a restaurant. And I'm not saying that they don't serve food or anything like that, because they do, but overwhelmingly they're becoming an event space that is not congruent with the things that the community in this neighborhood want. And we expressed that at that point in time, and the board was like, we need to give them an opportunity. We've given them their opportunity, and they've still continued to fail us in this community. And I understand that they're a business, and when you go into business, one of the things that you have to do is you have to make a risk assessment of, is this profitable? Is this the best location for this business? And just because they made a bad decision as far as on location or this business type, does not mean that the community should suffer because they need to stay in business. That's not acceptable. That's not okay. And if I may I share my screen for a moment?
No, sir, you can't do that, sir.
Why?
Mr. Green, you are Mr. Green. You are a witness. Okay? Questions, you respond to questions that are being asked to you, sir.
Okay.
He needs to ask you a question. If he asks a question and if there is a document that was in the record that he introduces in the record where you can share your screen, then you are allowed to do that. But if it's not a document that was disclosed in his PIP, you cannot share your screen, sir. Okay?
What about ABRCA records that are already submitted as far as complaints?
All right, hold on, sir. You're not the attorney, you're the witness, sir. He needs
I understand that.
He needs to ask you questions, and then we will go from there, sir. So let's, Mr. Kadir is asking you questions, and let's see where we go based on the questions that he's asking you, sir.
Yeah. Thank you, Mr. Anderson. Mr. Green, could you describe the noise level that you were seeing before the noise test on September 24th? How audible was music regularly, especially on Friday and Saturday nights, into your home?
It wasn't just Friday and Saturday nights. This was a 4 to 5 night noise event in which I could audibly and clearly hear music in my home. They were quite clearly go-go bands that were playing, in which I could hear them doing their cover of Maze, of Mary J. Blige, of whatever it is. I could clearly hear it in my home, and if I wanted to dance to it, I would be able to have a dance party inside of my house whenever they were playing.
And this was with your doors and windows closed.
Doors, windows closed. This is the middle of winter.
Yeah. And even you also have a backyard space in your row home?
I do have a backyard
Yeah.
space in my row home.
Could you describe the noise level when you're sitting in your backyard space?
The noise level in my backyard space renders it basically unusable if I don't want to partake in the party that is happening at that venue.
Would you say that the noise coming from the venue has affected the peace, order, and quiet in your home?
It has affected the way that I use the outside space of my home, in which I've made an investment to be able to enjoy that space. And again, it's one of, yes, they want to be a member of the community, but they shouldn't be able to infringe on the community just because they need to make a dollar.
Yeah. And so we've been talking about the noise level before the sound test. Would you say that there's been a drop in the overall average level coming from the establishment since the sound test on September 24th?
There has been a lowering of the volume, and I believe that is because of the complaints that have been filed regarding events in which there were cover charges charged, or whatever they want to call them, VIP, whatever. So I'm not really sure how to classify them, but when I look at it, it's a cover charge, it's a cover charge, it's a cover charge, and decidedly, since they were put on notice, about that, there has been a lowering of the volume. The go-go bands that were playing at the establishment have stopped playing at the establishment. And it's been a slight change in behavior, but the noise is still audible.
So even with your doors and windows closed, you've still been able to hear music from the establishment since the sound test on September 24th.
There are quite a few nights when I'm home on Saturday night or Sunday evening in which, I can clearly hear what's being played.
Yeah. And it's even louder when you're in your own back garden.
It's even louder in my backyard, in my backyard or garden, however you want to describe it, especially when they're having events in which they're hosted, in which there's a DJ and someone who's emceeing or hosting the party.
Yeah.
You can hear, quite audibly, that host or MC, doing the call and response to the crowd or and things of that nature.
Okay. So how would you say that the sound since September 24th, we're in this new era since the sound test, how would you say that the sound since September 24th has affected your quality of life in your home?
Again, as I said, it's affected the way that I use my home. Like prior to this business set of Oasis opening back up, I enjoyed my backyard, pretty much through the summer. This summer, I think I was out there maybe a handful of times just because I didn't want to deal with the noise.
Any other ways that it's changed your habits in your home, affected how comfortable you are in your own home?
Yeah, it's kind of embarrassing when you have people over and, they can quite audibly hear, the music in your house. And it's kind of, like, well, wow, like you live in a nice neighborhood, but, what exactly is this? It's impacting the quality of my life and, like the events that I have in my own home. And then, if I consider selling, at some point, it's going to affect my property values. Who wants to buy a home in what they believe is a residential district that has a business that operates as a de facto nightclub or entertainment venue?
Yeah, thank you. So just to recap, you live in a residentially zoned district. You can still hear the music inside your own home with doors and windows closed, and outside within your own lot, but still in your home, in your backyard. And you think it's affected your quality of life and your as well as your property value, and embarrassing when you have people over.
All of those things.
Yes, thank you. Have you, just a couple other questions. Have you talked to other members of our neighborhood about this, besides just those of us on the call?
Yes, as I said, I was when this business originally opened up, we had concerns that we would end up here, in which we're here. And, the community voiced those concerns. But as I said, the board was like, we need to be flexible and give them an opportunity. We've given them that opportunity and they failed at that opportunity. Now at this point, it's like, okay, how many more opportunities do we need to give them? How much more, power do we need to give them to infringe upon, our standard of living, our comfort with, noise and other things that, being able to charge that cover charge will allow them to do. And that, most nightclubs or in entertainment districts, one of the things that they're required to do is to have a security plan. I've heard them talk nothing of a security plan. I've heard them talk nothing of being able to manage this. The only thing they want to focus on is trash. Like we want to do community events. We want to do this. We want to do that. But they haven't focused on any of the things to become a good member of the community.
Thank you. Just a couple other questions. Have you been in touch with our ANC chair or ANC member about the noise?
Yes, as I said, when I originally filed this, I reached out to them and got absolutely no response on this matter. When they finally reached out to me, it was because of it wasn't Mr. Jackson. I believe it was their prior attorney reached out at that point in time to him, and then he circled back and was apologetic about not responding to my emails at that point in time.
Okay, so he hasn't taken any action. He hasn't helped to mediate between yourself and the business.
There's been no mediation or action taken from them. Their referral is back to the ABCA board in order to get some sort of resolution on this.
Yeah. And sorry, I had another question. I lost it. I think that's all I got. Thank you.
Mr. Jackson, any questions?
Yes, good afternoon, Mr. Green.
Good afternoon, Mr. Jackson.
First of all, Mr. Green, you keep saying that it's a residential area, but are you aware that this business is in a mixed use area, according to zoning?
It's in a mixed use business that it butts a residential district.
Not abutting, I'm talking about on record. Is it a mixed use area?
Are you going to let me answer the question? So, as Mr. Kadir has indicated, and I forgot the Aber investigator indicated, yes, Seta Oasis is in a mixed use district or zoned or whatever it is, but it abuts a residential neighborhood and residentially zoned properties. When they came out to do that sound test, they did not do it at Mr. Kadir's property. They did it at my property because I am in a residential neighborhood and residentially zoned. So when they did the sound test and they were able to hear all the audible noise up to the point where, Mr. Swaby, I believe it was at that point, discontinued or got combative during the tests, they were in my home recording and listening and documenting the audio levels for that test.
Okay, so being that you was aware of the test, now we're not speaking about Mr. Kadir because as you heard during testimony, that he's in a mixed use. So we're going to eliminate him from.
I
Hold on,
understand.
listen, let me speak.
Mr. Green, allow him to finish asking the question, sir.
Sure.
So we're going to eliminate him from this conversation. I'm only dealing with you as a resident. So when the sound test was conducted in your establishment.
Not my establishment, my home.
Your home. Did it come to a level that they said that the noise could not be heard according to the investigative report?
There was a point in which the investigators said that they could not hear the music. But again, I don't know exactly what the tuning or anything that was going on inside the restaurant because I was not present. I was in my home with the investigator doing whatever they were doing, the sound or listening on this side of it.
Did you have an opportunity to look at the investigative report?
I have not had an opportunity to read the entire investigative report from start to finish, But I do know that they did identify that the music was audible at some point in time. And as they did the test, they lowered the volume to the point that it was not audible at some point. What those levels are, I don't know.
Okay. Also, you mentioned that they made a bad business decision by putting their business there. Are you qualified to determine what's considered where business is supposed to be located in a mixed use zone?
I am not an expert on their finances, but I am an expert in some realms of business. And as I said, the prior businesses that were there all failed because of lack of engagement, lack of, people wanting whatever was being sold there. And their final pivot at that point in time was to entertainment. So if you're asking me, have I seen, this same business model fail in that location? Yes, I have. This business is failing in this location is why we're here right now, trying to get this additional endorsement so that they can, possibly stay afloat.
No, that's what I'm not asking you whether you agree to what their business decision in. Let me ask you this. You talk about business decisions failing. Have you ever supported this business?
My support of the business, I support a restaurant in that location. I do not support a business who wants to run an entertainment venue or a nightclub there.
Okay, how about the times when the music aren't being played? Have you supported the business?
What do you mean by that?
Okay, you said a nightclub. This is not a nightclub, it's a restaurant. So every time or all hours of the day, music is not being heard. So during that time, have you supported the business?
I support a restaurant being
I
there.
asked you, have you supported this business?
Sir, are you going to let me answer the question, or are you going to try to force an answer out of me? So
Go ahead,
again,
sir.
so again, I support a restaurant being there. Now, does this restaurant serve anything dietary that I would eat? No, it doesn't. I eat a very high protein, very, clean diet. So I don't do a lot of Caribbean foods. I don't do a lot that. So I do a lot of steamed and grilled and smoked things. If we want to get into my dietary requirements.
Now, I'm not really concerned about your dietary
Okay.
requirements
So
because
if that business does not, serve anything that I eat dietary wise, there's no reason for me to go there. Now, do I support a restaurant being there? Yes, I do. Do I support a nightclub or entertainment venue? No, I don't.
okay, you keep saying nightclub. It's not a nightclub. They're a restaurant that have entertainment. So being that that restaurant is not viable based upon you patronizing their establishment, there's plenty of other people that patronize their establishment that they depend on for revenue. So
If
your
that-
support is really not needed.
Okay, if my support is not needed, that is fine. And if they are doing so well as a business, then why are we here asking for this additional endorsement?
That's none of your concern. That's
Well,
a business decision.
you just made it my.
Gentlemen, this is Mr.
He asked me.
Jackson. Hold on, Mr. Jackson. You ask a question, Mr. Green. You answer. This is not a debate, okay? So Mr.
Yeah.
Jackson ask a question, Mr. Green answer, and let's move on. Any other questions, Mr. Jackson?
Yes. Lastly, are you aware that property value and the sale of your home is not determined by businesses in your area? It's determined by the comps. Are you aware of that?
Comps are one thing that factor into the value of a home, but location, and features of a community also factor into the value of a home. If you look at a home in, let's say, Chevy Chase that has no businesses with these type of entertainment endorsements attached to them, they sell for higher and more, and they're more desirable than properties that are adjacent to those. Now, if you don't understand that concept, I'm sorry, but that's just a fact of how real estate works.
Oh, I understand that concept very well. And this is not Chevy Chase. This is the District of Columbia, Northwest Washington area, mixed use.
Mr. Jackson.
No further questions, Mr. Chairman.
All right. Any questions by the board members? Oh, go ahead, Ms.
So I guess what I'm wondering is, have you lodged complaints, formal complaints with ABCA about noise in your home, and what was the result of that? And I'm talking about outside of what we heard from the investigator. Have you been lodging noise complaints?
Yes, I
And
have. Yeah,
what's been the
yes,
result?
yeah, yes, I have. So I've lodged a number of noise complaints, about the establishment. And I've talked to a number of the investigators and those answering the hotlines. And one of the things that was explained to me, and you all can verify this, and I don't want to be incorrect, and I don't know if it's 48 or 72 hours, but after a noise complaint is filed, ABCA investigators have 48 or 72 hours to get out and investigate that at that point in time. So there are a number of noise complaints that have been filed by me and my neighbors. But if what has been told to me by those investigators that they have 48 to 72 hours to get out and, do a formal investigation and it's not immediate, then all the complaints that we have, of course, there won't be any violations of it unless they're there and they're Johnny on the spot with it. So, have I done that? Yes, I have.
So
Have I
you've done that, but it sounds like, if I'm hearing you correctly, you don't have the back end information in terms of how quickly they actually got. I know what the window is, but you don't have data about how quickly they actually got out. What you know
There-
is that. Go ahead.
Oh yes, I don't have data as to how quickly they get out, and I think that question was asked to the investigator of how quickly once a complaint is filed that they respond, the ABCA investigators respond. And I've been told that a noise complaint is not necessarily a high priority issue depending upon what is going on that night in the city. And that's why I believe they have that window of either 48 or 72 hours. I'm not sure which it is in order to do that investigation of that noise complaint.
Okay, thank you for that.
Mm-hmm.
Nothing further, Mr. Chair.
Mr. Green, how many noise complaints have you filed against this establishment with ABCO?
I don't keep a count, and up until recently, ABCA did not issue, I guess, complaint numbers. You just entered it and requested a callback. Recently, I guess you guys have upgraded your system where you actually get a complaint number you're able to track. In the last year since they've been open, I think I filed no less than 6 complaints for either noise and or violations of them charging a cover charge without having the proper endorsement.
But you heard the investigator testify that they have no investigative history in the sense that our agency, and maybe you can correct me what's wrong, that our agency has not been able to substantiate that there's been any noise violation. So where's the
Yeah.
disconnect?
Well, if I file a noise complaint on a Saturday and they have 48 to 72 hours to get out and there's other high priority issues that are going on, by the time they arrive on either Monday or Tuesday, I would expect them not to find any noise. That's just simple math.
All right, so you're saying that for the 6 or so noise complaint that you have filed, that you have not gotten any immediate response from the agency to any of those 6 complaints.
Well, I think that's been obvious if there are 20 complaints that have been made and none of them have fielded anything, that is not a issue of not us being a reporter. There could be a lack of manpower, a lack of, priority. And, if they're doing their job in their investigative window, again, that 48 or 72 hours, I don't know which it is. That means that they could arrive on Monday or Tuesday and that event is long over. There's no noise. There's no, patrons inside of the establishment in order to go, yes, there was a problem here.
All right. Now, ABCA came to your house and did a noise test. Is that correct?
That is correct. That's what's documented in the report.
And isn't it, I mean, and from what I heard the investigator testified was that they were unable to hear noise in your residence until at least this one band or whoever it is, that the music was at the max. That was the only time they were able. The investigator was able. I'm only saying what was testified to.
I
So
understand that.
can you explain that to me, sir?
Yeah, so I can't qualify what that sound engineer, quote unquote, said was the max. Like if I know that this is pending and someone goes, "Hey, what's the maximum volume that you can turn up to?" They may have gamed the system. I don't know. I'm not
But
saying
no,
that they.
but the question I'm
Let
asking
me.
you, sir.
Can I finish?
No, Mr. Green, you're not answering the question. The
I'm
question
trying.
I
I'm
asked
trying.
you.
I'm trying to
No, sir.
answer the question.
No, sir. I'm sir. Let me ask you a question, sir.
Mm-hmm.
There was an investigator in the establishment, and there was an investigator in your home. Isn't it? I'm saying, isn't it correct that it was reported to you that when they could not hear the noise in your establishment until at least this one band, they had turned the music to the maximum volume.
Again,
Isn't that correct?
again, that was what was stated. I don't know what they identified as I'm not a sound engineer. I don't know what they designated as the max from that particular sound test, but I can attest, and I'm under oath right now, that as clear as day, if they want to play a Frankie Beverly and Mays song when they had a go-go band in there, I could hear every note, every high, every low in my bedroom.
What type of music was being played when the investigator came to your house, sir? What music was being played?
They had a band playing, and they also had some pre-recorded music that they were playing.
And
Now the genre and the artist, I couldn't tell you what that was, but there was a point in which the band was playing in which we could audibly hear that in my home, which is documented in the report.
and the report stated that this was when, at least for this band, they're saying that if they play, I'm asking, and so this was in your home. I was not there.
I'm giving you an answer. I was in my home. I was not in the establishment, so I don't know what they quote unquote designate as the maximum volume or if they were gaming the system. I can't tell you. I wasn't present in the establishment.
Now, did you have a conversation with the investigator regarding the what was being played, the volume, what was being played? Did you have an opportunity to
I
speak
didn't
to the
have
investigator?
I didn't have input into the musical choice that was played when they did the audio tests.
No, I'm not saying that. You're saying
Okay.
that you don't know whether or not they game the system. I'm saying, did you have an opportunity? Because I'm saying you're in your home and you're saying that you're hearing music, and the investigator is trying to substantiate, or they're doing a noise test, and the investigator came and said, "Okay, I'm in your home. I don't hear any music playing." So did you say to the investigator, well, I don't that doesn't make sense because routinely I hear music. So
Yes, that was part of a conversation that we had while we were here. And again, when they turned the volume to quote unquote their max, the investigator was able to hear the music in my home. Now, what that quote unquote max was, I can't tell you because I was not in the establishment.
But that was the only time when the investigator was there, that is the only time you heard the music. If it's when they say the music was quote unquote turned to the max. Is that correct?
That is quote unquote, based on what's in the report, I'm assuming. And again, like I said, I haven't read the report, from beginning to end to go, this is incorrect or this isn't. But if you're saying, I can't say that, but I know that while we were in my home, I could audibly hear the music. The investigator could audibly hear the music at some point during that test.
Now you're aware that, as you stated, you have made noise complaints, and the only way a complaint can be substantiated is if the investigator is in your home and they hear the noises. You're aware of that's the standard. Is that correct?
I'm aware of that, and I have offered up, to the investigators, that if there's a noise complaint and they want to come into my home in that evening and hear it audibly, they're welcome to do that. Now, again, if they have other priorities or that 48 or 72-hour window to respond, if they show up on Monday, there's obviously no music or noise for them to hear at that point in time.
But I'm not aware of the standard, and I have been
Again,
chair. Hold on, Mr. Green. I've been the chair for this board for 10 years, and this is the first time I'm hearing that. So I don't know whether or not, and I will address this with the director if this is a problem. But I have never been. I have been in hearings and I've heard a lot of noise complaints, but I've heard that if there are other priorities going on, that yes, they might not get to your complaint at that point. But I have never heard that the standard was that they will get back to you 48 to 72 hours, because you're correct. You are correct. If the noise occurring, if I show up to investigate 48 to 72 hours, I'm not going to hear it. So I am concerned, and I will investigate that to ensure that that's not the policy of the agency. However, I do understand that depending on staff and depending what's going on that night, they might not get an opportunity to come to your establishment at the point that you made your complaint. Okay, that's all I'm saying.
Right.
Um,
And I appreciate that. And, and again, the point that I was trying to make with, if there have been 20 complaints, we aren't just pulling these complaints out of the air. They're from different people at different times on different days. It's not a coordinated effort in order to make these complaints. So there is something happening. It's just that it has not been substantiated, by whatever reason, priority, timing, or whatever that may be. But there still is a problem with noise. As the investigator said, there is no sound insulation in this establishment in order to keep sound within the walls of this business. There's none.
well, there are 20 complaints, but the report didn't say there were 20 noise complaints. And the standard is that because you live in a residential zone, you should not hear noise in your property. Okay, so but as far as you're concerned, the regulation does support you that, but in order to the investigator has to come to be in your property and substantiate it. But all right,
And that sounds like a problem that ABCA needs to find a solution to if the community is reporting problems in order to get investigators out in a prompt manner in order to investigate those. Not, just a point to make.
I know, sir, and I've said before, the board looks at their investigative history, and if you're to look at the investigative history and there are no substantiated complaints, then that's problematic because they can say that they have a clean record, which in this particular case, their investigative history states that they have a clean record.
Now, I hope also the board takes into history their testimony from their original license, where they stated what type of business they want to run and their intentions also.
The unfortunate, they're giving a license, sir, and I know you said that the community had made certain comments about what was going to happen, but not for them requesting a change in their license, we would not have had this hearing. So they still wouldn't have an investigative history. They would not. They're not here today because of complaints by the community. They're here today because they want to make a change to their license, and this board determined that based on the change that they want to make to their license, this is of concern to the community. So therefore, the community has an opportunity to input. So when you stated that you raised certain concerns initially, and the board says, well, give them a chance, this is not there's no information currently to say that they have not done what they at least presented to the board at their initial hearing. That's all I'm saying, because there's nothing in their investigative history to state that they have not complied with the law. But that's neither here or there. All right, any other questions by any of the board members? Mr. Jackson, any questions of Mr. Green based on the questions that were asked by the board?
Yes, Mr. Green. Did you have a chance to look at the investigative report or read the investigative report?
I think I've answered that question multiple times.
Mr. Green, it's a long day. This board has been here since 9:30 in the morning, and we're gonna work after this hearing is done. So let's just answer the question so we can go. You know, it takes longer when you don't answer, then just answer yes or no. Move on, please.
I for the record, for everyone's, I am aware that there's a report. Have I read it from cover to cover? No, I haven't. I've seen bits and pieces of it.
Okay. Well, in the report, the investigators stated that they made independent visits to the establishment without anyone making telephone calls. In each visit, they did not substantiate that any noise was heard emanating from the establishment. Were you aware of that?
Do you have days of the week that they visited?
Yes, that's in the investigative report.
Well, if you're looking at the investigative report, was that a Saturday or a Sunday night? Was it a Friday night?
Investigative report.
Well, you're asking me a question.
You said you had a chance to look at it.
All right. The investigator has been to the establishment 13 times. I don't know. I guess we could have asked what days, but I'm sorry. The investigator testified earlier that they have visited this establishment 13 times, okay, as part of their investigation, okay? All right. But we can go back to see. All right, let me see. The investigator testified that they went Thursday, Monday, Friday. Friday they did from 12 p.m. to 12:30. Thursday in the day, Friday from 10:30 to 11 o'clock. Sunday from 1 a.m. to 1:10, and Sunday from 3 p.m. to 4 p.m. So if you look at page 7, there's only 7 documented visits here. However, the investigator testified that they went there 13 times. And so they've been there during the day and during the night. All right. Any other questions, Mr. Jackson?
No further questions from this hostile witness.
Mr. Jackson, that is not necessary. Mr. Green, you don't need to respond. Mr. Green, we're doing well. It's 5 o'clock in the day. Okay, we still have another witness to go. And okay. All right, Mr. Kadir. Any questions of Mr. Green based on any redirect of Mr. Green?
Yeah, just to confirm, Mr. Green. So I was there too, but you heard the music during the sound test on September 24th. There was a level of music that you heard in your home with doors and windows closed on September 24th, correct? We heard some music in there.
That is correct.
Yes. It has previously, yes or no, has been louder than that you've been able to hear in your home.
Yes.
So that means that the volume that the band was playing at was not the maximum volume that this establishment can emit, correct?
Mr. Kadir, you can't. I'm going to object. You can't ask that question because you could have asked that question to the investigator. Sure. All right, so let's move on. All right. Any other questions you need to ask?
No further questions. Thank you.
Mr. Green, I know you've been here a very long time. You've been here since the beginning. Thank you very much, sir, for your testimony today, sir. And thank you for your testimony, sir. And
no problem.
Great day. All right. Mr. Kadir, do you have another witness?
Out of interest in everyone's time, if I can, I'll decline to call our last witness. I don't think he has much to add that Mr. Green will not be able that Mr. Green has not already said, as he lives in a residential area near to Mr. Green.
All right, thank you. All right, it's closing. Do the parties need a couple of minutes? Where's Mr. Okay. Mr. Jackson, do you need a couple of minutes to close, or Mr. Kadir, or are you ready to do closing?
I'm ready to close.
I'm ready to close as well.
This is what I need. This is what I need. I need you to be specific. What it is you're asking the board to do. Okay, this is what I need the parties to be very specific. What is it they're asking the board to do? Okay, go ahead, sir.
Is that
Who's
me or
first,
Mr. Jackson?
Mr. Commissioner?
Mr. Jackson goes first. You go. Mr. Jackson goes first. But I need both parties to tell us that.
Understood. Thank you.
But Mr. Jackson goes first.
Yes, in closing, I would like the board to continue to allow the application to be processed, to add cover charge and dancing. We feel that based upon the investigative report, the sound test, and the testimony, that the protestants failed to provide documentation nor evidence that the establishment with those two added endorsements would have an adverse impact on peace, order, and quiet.
Okay, that's it? That's it, Mr. Jackson?
Yes, sir. That's it.
Mr. Kadir.
Yes, thank you, Mr. Anderson. And once again, thank you to the chairman and the members of the board for taking the time today to hear us and to hear what we have to say about the proposed modification. Just to reiterate, we ask that the approval of the proposed modifications be conditioned on soundproofing the business, the establishment, so that music or other noise cannot be heard from the establishment in residential areas. And we ask that it be conditioned on creating a safety plan or a crowd management strategy for the crowds that will gather outside of the establishment, with the addition of a cover charge and larger crowds going to a dance floor. We have heard testimony under oath from Mr. Green that music is still audible from his home, even since the sound test was conducted on September 24th. There is music that is louder than the music that was heard during the sound test on September 24th. The music continues to affect our lives, our livelihoods, our qualities of life. As Mr. Green even mentioned, our ability to have friends, company, family over, because it can cause embarrassment to have a restaurant, so to speak, pumping music across the alley from you that affects your ability to use all the parts of your home and be able to sit quietly in your yard, or to be able to open the window on a summer evening. And so we ask that this be taken into consideration, that these modifications not be approved, especially to the summer garden, unless that summer garden, as well as hopefully the entire establishment, be shown to be adequately soundproofed, so that they can play the music that they want to play for a dance night, for an event, for karaoke, for stand-up comedy, but it just does not affect our lives. I ask, my hope is that I can continue to live in my own home in peace and quiet, but I hope that it's been shown that it should not be able to affect the lives of people living in completely residential zoning. And I do understand the difference between my mixed-use zoning and the residential zoning, but I hope that it also should not go on to affect the lives of people who live in mixed-use zoning. On the point of the crowds, again, to reiterate, as we saw with the large crowd on September 20th, that was an event that did not even have a cover charge. That was an event that happened very quickly with little planning. And if that kind of event were to happen again, we need to hear guarantees from this business that there is a way to keep the community safe, to keep the neighborhood safe, to allow public access to sidewalks, to make sure that people are not walking in the streets, and to make sure what to do in the event of an emergency with a larger crowd inside or directly outside waiting to be let in, for example, of this business. So we have proposed solutions, soundproofing and crowd safety. We think that it should not be on the residents of the community surrounding the establishment to change our lives around this establishment, but rather that they should have to accommodate the neighborhood that they moved into, both the mixed-use zoning that immediately surrounds them and the residential community that they look onto, who still lives just a block or two away and is still affected by the operations of this business. Thank you very much again for your consideration. I really hope that you can hear what us members of the community have been able to say. Thank you so much to the board and to Mr. Anderson.
Thank you, Mr. Kadir. All right, thank you, Mr. Jackson. The record is now closed. Do the parties wish to file proposed findings of fact and conclusion of law or waive their right to do so?
I'd like to waive my right and allow the board to make their decision.
Could you explain this, Mr. Anderson?
Meaning that you would wait for the transcript, listen to the transcript, and basically say these are the facts that were approved in this case, and this is what the law states on these issues. So basically, drafting a legal brief after reviewing the transcripts and providing that information to the board.
Sure. Yeah, I waive my right.
All right, thank you. All right, the board will issue a decision within 90 days. So let me close the record officially on this. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 PRO 00082 SETA Oasis, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberating upon case number 25 PRO 00082 SETA Oasis for the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Ms. Quinn, I
Mr.
second.
Jones, I second the motion.
Ms. Quinn and Mr. Jones have seconded the motion. I will now take a roll call vote on the motion before us now that it's been properly seconded. Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice that the ABC Board will recess this proceedings to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. Thank you thank you very much for your presentation. The board will issue a decision in 90 days. Thank you. Have a great day.
Thank you. You as well.
Thank you. Have a good night.
Bye-bye.
All right.
So I'm going to close the record for the day. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on January 16th for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board investigative agenda, legal agenda, and licensing agenda for January 16th, as published in the DC Register on January 9th. Is there a second?
Mr. Meadows, I second.
Mr. Meadows has seconded the motion. I will now take a roll call vote on the motion before us now that it's been properly seconded. Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones. Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. As the motion has passed 4-0, I hereby give notice that ABC Board will hold this closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar on ABCA's website, and published in the DC Register in as timely a manner as practical. We are adjourned for the day. I would like to thank all members of the public who participated in our hearings today, and also our board members who gave their time and attention to this matter. We're now adjourned. I now ask all board members to return to executive session for further action. Good afternoon. Thank you.